I hope not. Sorry about that. I think they'll be able to.
Yes.
Well, I took the file
Yeah,
because I figured we did the in-person first. So I
but you're
just
probably right.
wheeled all those cases out there.
Better news.
Howdy, Mom. Yeah.
Who we miss? Sanders, Matthew Thrasher. William Perdue. Huh?
Larry.
Megan? Megan?
Megan, he's talking to you, Megan.
Yeah.
Okay, ready, Judge?
No. I need to talk to Megan first.
Okay, Megan.
Megan,
He won't
you need
talk.
to email me those questions. I can't get a fax from you for some reason.
I already have.
Okay, let me see if I can pick it up then. Okay. I have them. We can start court now.
All right. Clinton Circuit Court now in session. The Honorable Daly Williams presiding. Make sure all your cell phones on silent. Bow your head for a moment of prayer. Thank you. May be seated.
We have a case out of order, do we?
It should be first on your list.
Timothy Brown, Commonwealth versus Timothy Brown. Commonwealth versus Timothy Brown. Good morning, Mr. Brown. I'm sorry I'm not there with you today. I have COVID, and I'm sure you don't want it. I can tell you. You were born in 1988, Mr. Brown.
Yeah.
Last four digits of Social Security number 7076. Now, Megan, do we have another arraignment?
Yes.
Okay. Will you pull that indictment there? And the grand jury of Clinton County has returned an indictment charging you. And Megan, will you pull the indictment and read it there?
Reckless driving and fleeing or evading police in the first degree.
Yeah, I'm going to enter a not guilty plea for Mr. Brown. If that's okay with you, Mr. Brown, I enter a not guilty plea for you.
On this charge right here that I have in front of me?
Yeah. On that new charge. I don't want you to say anything because anything you say could be used against you. Okay. So that's the reason I'm just going ahead and enter you a not guilty plea.
Ain't I representing myself?
Well, okay. That's what I'm fixing to explain to you here. I'm not casting any dispersions on you, but the law says there are certain questions that I have to ask you before I can make that decision. Okay.
Yeah, I'm definitely smart enough to stand trial.
Well, it has nothing to do with what I think of you or what anybody else. Listen to me. It's no reflection on you. I just got to ask these questions because the Supreme Court told me to. Okay.
Yeah.
Okay. Mr. Brown, have you ever studied law?
No.
Have you ever represented yourself or any other defendant in a criminal action?
No.
You realize that you're charged with the crimes that have been listed previously. You understand the crimes you're charged with.
Yeah.
You realize that if you're found guilty of the crimes in the counts that you're charged with, that you could be sentenced to multiple years in prison.
Yeah.
You realize that if you're found guilty of more than one, the court could order the sentences to be served consecutively, one on top of the other. Is that right?
Yeah.
Are you familiar with the Kentucky rules of evidence?
No.
You realize, do you not, that the Kentucky rules of evidence govern what evidence may or may not be introduced in the trial in representing you, and you must abide by these rules?
Yeah.
Are you familiar with the rules of criminal procedure?
No.
You realize You realize, do you not, that these rules govern the way in which a criminal trial is conducted? You realize that?
Yeah.
You realize that you do not, you realize, do you not, that if you decide to take the witness stand, you must present your testimony by asking questions of yourself. You cannot just take the stand and tell your story. You must proceed question by question through your testimony. Do you understand that?
Yeah.
Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than yourself. I think it's unwise for you to represent yourself. You're not familiar with the law. You're not familiar with procedures. You're not familiar with the rules of evidence. And I would strongly urge you not to try to represent your case. Now, in light of the penalty,
More time than most, they really just don't care anyway. So
I've got to go through this stuff.
Yeah.
Okay.
Well, I'm just telling you my fault.
Okay, wait just a second.
You know.
Now, in the light of the penalty you may suffer if you're found guilty in a lot of difficulties to represent yourself, is it still your desire to represent yourself and give up your right to be represented by a lawyer?
Yeah.
Okay. Is this decision voluntary?
Yeah.
Okay. Well, I find the defendant has knowingly, intelligently, and voluntarily waived his right to lawyer, and I will therefore permit him to represent himself.
All right. Thank you, Your Honor.
Okay, thank you. Okay, that finishes that case. And I guess we'll go to out of custody, folks. James Abston.
He won't have one because he has a trial scheduled and he's gonna represent himself at trial.
James that. James that.
Commonwealth versus James Abston. 22 CR 0023. Are you James Abston?
Yes.
You born in 1952?
Yes.
Last four digits of your social security number are 2694.
Yes.
We're here for a pre-trial conference. What do we have, Mr. Stockton?
Please, Your Honor.
Felony plea?
Yes, Your Honor.
A motion has been tendered that says you wish to enter a plea of guilty today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
It's freely and voluntarily given. Yes.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice? Did he answer me?
He did, Judge, he did. He said yes.
Okay, take your, you're gonna have to speak up, man, okay?
Take your mask off. Talk loud. Take your mask off. Talk loud.
You have certain rights in the Kentucky and United States Constitution. I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. You understand entering a guilty plea today.
Yes.
You give up those rights. Now, I may consider the Commonwealth's recommendation. I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report. done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Your Honor, on plead guilty.
Sir, will you move over to the left? Put your mask back on and move over to the left. Thank you.
Mr. Ashton will plead guilty to operating a motor vehicle while under the influence. First offense, he'll receive a fine of $200 plus costs. He will also plead guilty to wanton endangerment, first degree, 2 counts, receive a sentence of 5 years on each count, remain concurrently for a total of 5 years. Supervised, he'll enter and complete the Clinton Specialty Program and receive credit for time served. Pay court costs at discretion of the court.
What are the court costs in this?
$155.
Well, there's a DUI. It's bound to be more than 155.
The total fee was how much was the fine?
$200 plus.
$960 total.
$960. Do you need some time to pay that, sir? Sir, will you need some time to pay that?
Yeah.
I'll let you pay it $50 a month, starting 30 days from today. When is the next rule day?
Judge, regarding a sentencing date, I think I told you wrong. This is actually a pretrial diversion offer that Mr. Ashton has accepted, and the paperwork, reflects that.
Well, he cannot pretrial divert a DUI.
No, it's just a felon.
The felony charges.
Have you been pretrial diverted in the last? Excuse me a second. Have you been pretrial diverted in the last 5 years?
No.
Okay. Have you had any felonies in the last 10 years?
No.
Are you currently on probation?
No.
You understand, as far as the felony charges, if you complete the pretrial diversion, the case will be dismissed pretrial diverted. You understand that?
Yeah.
However, if you violate the terms of pretrial diversion, come in and I'll order a pre-sentence investigation for you. Sentence should be a convicted felon, and that can be used to enhance felony convictions in the future as far as giving you more time. Do you understand that?
Yes.
You understand that the DUI that you have will be enhanceable too. If you get a second DUI or any other DUIs after that, this could be used. You understand? Okay. Okay, is that your signature on there?
That's your signature?
Yes.
Okay, I will accept the pretrial diversion. When is the next rule day?
June 9th.
Okay. Okay, thank you very much.
Thank you. Megan, there's a drug court or special report.
That was already in.
Okay.
I believe that was in our.
You might check, because the copy I had didn't have contact information.
Ivy Brannon. Commonwealth versus Ivy Brannon, 22 CR 0009. Are you Ivy Brannon?
Yes, Your Honor.
What year were you born?
98,
What are the last 4 digits Social Security number?
0736.
Okay, you're here for a pretrial conference. Who's your lawyer?
Brad Sheffett.
Okay, I didn't see Jeff. What you got, Mr. Stockton?
Your Honor, Ms. Branham is co-defendant with Travis Flowers. he's supposed to enter a felony plea today, and once he enters that plea and final sentence, I'll move to dismiss Ms. Brown's case. If you want to put this off to July, we shouldn't have Mr. Flowers done then.
Okay, what's July date?
Is
14th. July 14th.
Okay, you come back on July 14th, okay?
Yes, Your Honor.
David Brown. Commonwealth versus David Brown. 22 CR 0016. Are you David Brown?
Yes, Your Honor.
Born in 1972.
Yes. Your Honor.
Last four digits of your social security number 3541.
Yes, sir. Your Honor.
What do you have, Mr. Stockton? You move to the left, sir.
Yes. Okay.
Your Honor, we'd ask that Mr. Brown be set for the settlement conference the next motion day. He was at Eastern State during the last settlement conference.
What is that date?
May 31st at 9 a.m.
Okay, you shall appear at the courthouse there for a settlement conference on May 31st at 9 a.m. and your next court date's on June the 9th, okay? Thank you very much. Laura Burchett.
Worry about that.
Commonwealth versus Laura Burchett, 22 CR 002. Are you Laura Burchett?
Yes, Your Honor.
What's your year of birth?
1979.
19 what?
79.
Okay. What's the last four digits social security number?
9947.
Okay, we're here on a pretrial conference. You move to your left a little bit.
I'm on the other side. Need to pose, so.
Felony
Yeah.
plea, Your Honor.
Okay. Get her over behind the podium there. A motion has been tendered, says you wish to enter a guilty plea. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, to be represented by counsel at the jury trial, to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Do you understand that by entering a guilty plea today, you give up those rights? Now, I make his Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept it. Prior to accepting it, I will wait the pre-sentence investigation report to be done for probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. You step to your left, ma'am. Mr. Stockton, what's the offer?
Your Honor, upon a plea of guilty of trafficking in a controlled substance first degree, the defendant shall receive a sentence of 5 years, probated for 5 years. As of the entry of this plea, she served 82 days in jail and shall receive credit for time served. She'll pay court costs discretion of the court. She'll also obtain and maintain gainful employment.
Is that what you agreed to?
Yes, sir.
Has anybody threatened or coerced you to do this?
No.
You're pleading guilty because you argued. Is that correct?
Yes.
I've explained your constitutional rights with you. You waive those and allow me to impose the punishment. Now, you understand that by entering this plea, your felon and any future convictions could be enhanced as far as the range of penalties concerned. You understand that?
Yes,
That's your signature on the document there.
yes, sir.
Okay, order a pre-sentence investigation report and schedule a sentencing on June the 9th. And is she to go into custody now? I understand.
No, she's getting credit for time served.
That's correct, Your Honor. She'll be on probation. But if she
Okay.
goes back in custody, it'll be up to her.
Your Honor, there's a waiver of dual representation being executed as well.
Who else do you represent that's involved in that?
Paul Richie, who's already been sentenced in this court.
Okay. Is that correct, ma'am? You waive dual representation?
Yeah.
Okay, thank you very much. Sarah Cash. Commonwealth versus Sarah Cash. Excuse me. 21 CR 00118. Are you Sarah Cash? You're here for the purpose of arraignment. What is your year of birth?
1993,
What's the last four digits of your social security number?
5219.
The grand jury of Clinton County has returned an indictment. Megan, will you read the charges?
Trafficking in a controlled substance in the first degree, first offense, class D felony.
You understand that charge?
Yes, sir.
Do you have an attorney?
Brad.
Okay, I'll continue the appointment. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
Okay, Ms. Cash, your attorney was just handed some pretrial discovery to help prepare for your defense. You'll be back on May the 31st at 9 a.m. for negotiation and June the 9th for your next court appearance. Both of them requirements you bond.
Your Honor, if I may, this is an old case on an undercover drug buy. Ms. Cash previously entered a plea where she's did quite a bit of jail time. She's currently in the specialty court. She's doing really well. I think she's probably doing better right now. She's been a long time. And I'm willing, if the court is to continue this generally and see if she can maintain her good behavior and then dismiss the case if she completes drug court. But she's been monitored very well.
Well, she's arraigned now.
Yeah.
We could set it.
I'll just continue. Let's just set it out in December sometime. What's the rule day in December?
First,
December 1st?
yes.
Okay, your next court date is December 1st.
If there's a problem, I'll renotice it early.
Okay. Edward Daly.
Right in the middle.
Commonwealth versus Edward Daly. 22 CR 00013. Are you Edward Daly? You were born in 1951. Were you born in 1951?
I don't think so. You can try and see if it sounds like that.
Was you born in 51? Yes, 1951. 3/16/51.
What are the last four digits of your social security number? Is that better?
That's 4 digits.
Yeah. That's one.
Yeah, it'll hang down.
Okay.
What are the last 4 digits of your social security number?
2842.
Okay. We're here today for a pretrial conference. What do you have?
Judge, this is the case, I believe I'm going to need to pursue some competency before we proceed. I've been made aware of some concerns. I wouldn't feel comfortable proceeding with trial or a plea until those are dealt with.
Have you filed a motion?
I have not, but I will be doing so in short order.
What is the charge?
It's one endangerment, Your Honor. This is the second go around for Mr. Daly. Back in 07, he was charged with harassing his neighbors. This time, he's also charged with shooting up toward their home and their direction. So if this case is put off anytime, I want it to be clear. If there's a problem, I just won't be able to call the court and have him incarcerated because this is a dangerous situation. And he shouldn't even be allowed to have a firearm right now. I wouldn't think while he's on bond. And what are the conditions of his bond? But I really don't want too much of a delay in this case because I want to be able to protect the people that live next to me.
Well, Judge, we have, I would think there's already no contact in order and have no objection to no firearm.
What good is a no contact if you claim this gentleman has a mental problem? You know, I'm going to modify the conditions of his bond and keep his bond in effect if he'll waive his Fourth Amendment rights to allow his house to be searched. I don't want any weapons in his house. No long arms, no long guns, no short guns, no pistols, nothing.
No, you don't.
That's fine, Judge.
Okay. Well, you file your motion and we'll have it back up. Are you going to file one just for me or what are you going to do?
Yeah, that will be the next part.
Well, you know, I think that I'm going to start just sending people to KCPC. And if you disagree with their evaluation, then you can file a ex parte motion with me.
Well, obviously that's up to the court. I think more often than not, my expert will find that my clients is competent and then KCPC, the transportation and wait. If you want to talk about delay, we're looking at Christmas if KCPC gets involved with this case. They're 6 months right now.
Mr. Stockton, are you there?
Yes,
Move to your left.
Order outpatient at KCPC and it would be done a lot faster. You wouldn't have, as long as he's not in house, it wouldn't be as much.
Well, if Dr. y'all move to the left over there. You and your client move to the left so Mr. Stockton can be there also. Mr. Stockton, what if Dr. Grogan says that there's some kind of problem? Are you going to accept Dr. Grogan's statement?
No.
Well, that's true.
I'm not. I'm going to ask for KCPC to evaluate.
Right. So there's, we'll try to get an outpatient KCPC. And if he can get if he disagrees with that, get Dr. Grogan. If you still want him, you can file a motion. Okay.
We'll do an order then. Right.
Okay. Austin Edwards.
Judge, were we going to set this for a review?
Well, it's next month.
Okay.
It won't be ready next month, but have him back on June the 9th. Austin Edwards.
Can you see both podiums, Judge?
Yes. Commonwealth versus Austin Edwards. Mr. Cross, put your client in the middle and you get to his left, okay? Yeah, that you get to his left, okay? That way y'all can go back and forth. Thank you very much. Are you Austin Edwards?
Yes, sir.
Were you born in 1999?
Yes.
Last four digits of your social security number? 5. Okay, we're here for a pretrial conference. Mr. Stockton, what do you have?
I don't know. I've made a pretrial diversion order and I don't know where they stand. Offer, I should say.
Your Honor, we have, Mr. Edwards and I are considering the order. I'm sorry we don't have a decision made today. I wanted input from his mother on that. And there's possibility we may want to present there's some rather extenuating circumstances in this thing. So I think if we could pass it one time, we'll know what we're doing.
We can set it for the 31st of June. If we don't have a resolution, we just get a trial.
That's great.
May 31st for negotiation, June 9th for next court appearance. Travis Flowers.
Judge, we were informed this morning that he had tested positive for COVID. We requested proof to be sent, and I don't believe anything's been sent.
I'd asked for a arrest warrant. I've had him in NCIC multiple occasions before. I don't know what his bond is, but I'd be bound to revoke his bond unless he's got proof.
It is arrest warrant for failure to appear. Pamela Guffey. Commonwealth versus Pamela Guffey, 21 CR 00119. Are you Pamela Guffey? Are you Pamela Guffey? You got to say something. You can't shake.
Yes.
Speak up, please. Okay. Born in 1977.
Yes.
What are the last four digits of your social security number?
6476.
Okay, we're here today on a pretrial conference. Mr. Stockton, what do you have?
Your Honor, can we pass this 1 month? And I believe we'll have a resolution. It's May 31st and June 9th.
Okay, be back May 31st for negotiation, and June the 9th is your next court date, man. What time is it getting to be?
On the 31st, it's at 9 o'clock.
You know, what time is it now? I don't have a clock with me.
9:42.
Okay, so we got to get on with these. I was just seeing if some of these jails will hang up on us if we don't. Nikki Hutcherson.
I don't know why that case is on the docket.
I believe Brad Shepherd. You wanted it off or something?
No, the jail thought she was in the jail down there and they wanted her on, so we just need to take it off the docket.
I had a note for 3 cases put on and there's all
She's in
Brad. I seen
rehab
them.
somewhere.
Oh, they make their mind, but I didn't ask.
Okay, got it.
Richard Mason. Commonwealth versus Richard Mason, 18 CR 0030 probation revocation, and 22 CR 0006 pretrial conference. Are you Richard Mason?
Yes, sir.
Were you born in 1983?
Yes, sir.
Last four digits social security number of what?
5063.
Okay, you step to your left there, sir. Mr. Stockton.
Your Honor, Mr. Sheffett and I have consulted about this case. I need to interview a witness and I need another pretrial and motion day, negotiation.
May 31st for negotiations, 9 a.m. Next court date, June the 9th. Okay. Ida Myers.
That's an active warrant.
Active warrant not here.
Yeah. Nita Neale. Nita Neale. Are you Neale?
Yes, sir.
What year were you born?
Oh, 1973.
What are the last 4 digits of your social security number?
8417.
Okay, you're here for a pretrial conference. Are you represented by an attorney?
David Cross. Good day.
Where is he?
I'm here, David.
Okay. Mr. Stockton?
I think the last discussion I had with Mr. Cross is he just got in this case, and I was going to put it on the 31st of that.
Yes, Your Honor, I got it before the negotiation day, and I actually.
May 31st and June the 9th. Okay. Paddy Poor. Commonwealth Kentucky versus Paddy Poor, 21 CR 00133 and 21 CR 00132. Are you Paddy Poor?
Yes,
What's your year of birth?
December the 2nd, 1973.
Last 4 digits of your social security number.
3805.
Okay, what do we have here, Mr. Stockton? We're here for pretrial conference.
We have a plea here, I don't have a copy of my file.
The felony plea?
It's a felony plea, yes.
A motion has been tendered, ma'am, that says you wish to enter a plea today. Is that correct?
Ma'am.
Yes. Now what? I didn't hear that.
A motion has been tendered. It says that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in the indictment?
Yes.
Have you had plenty of time to discuss your case, the evidence with your attorney, and are you satisfied with his advice?
No. Yeah.
Okay, well, I don't know whether you are or not.
Yes, I am.
Okay. You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go over all of them, and at the end of it, I'm going to ask you if you understand, okay?
Yes.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. You have a right to be represented by counsel at your jury trial. Your right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. Your right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty. You understand that by entering this plea, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. Prior to accepting any recommendation, I will wait the pre-sentence investigation report. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you can withdraw. You understand that?
Mhm.
Yeah.
Yes.
Okay, step to your left there, if you would. Step to your left. Thank you. Mr. Stock.
The offer would be she plead guilty to trafficking and controlled substance first degree, 2 counts, receive a sentence of 5 years on each charge to run concurrently for a total of 5 years. She'd serve 120 days in home incarceration. The balance will be supervised. She'll have that set up within 24 hours of the entry of this plea. She'll be referred to the SSC and follow all recommendations and pay court costs at discretion of the court.
What is the court cost?
$155.
Okay, is that your understanding of your plea, ma'am?
Yes.
Okay, are you pleading guilty of your own free will because you are guilty and for no other reason?
Yes.
Now, knowing your constitutional rights that I have read to you, are you agreeing for the court to fix your punishment?
Yes.
You understand And that by entering this plea, any future felony convictions could be enhanced as far as the range of time you serve. You understand that?
Yes,
Okay, is that your signature?
yes.
Yeah, I will accept the pre-sentence investigation report. I mean, listen, I will accept the plea and order a pre-sentence investigation report. You come back on June the 9th for sentencing. Now, you want her to have that, well, you said within 24 hours, she ought to have that ankle bracelet on. Is that right?
Yes, Your Honor.
Okay. You make sure you do that and have your attorney send proof to the Commonwealth Attorney's Office, okay?
Your Honor, we're executing a dual representation. In this case, she has a co-defendant, John Luttrell, who the court will see later in the docket.
You understand that, ma'am? That's all right. It's okay. That's okay. Robbie Scott. Robbie Scott. Commonwealth versus Robbie Scott. 21 CR 0069. Are you Robbie Scott?
Yes, sir.
You born in 1980?
Yes.
Last four digits social security number.
0-0-8-7.
It's 21 CR 0069. We're here for a pretrial conference. Mr. Stockton, what do you have?
Your Honor, I have entered an offer. James Acton represents the co-defendant Chad Scott. He couldn't be here because I signed an agree order. I'm trying to get Chad Scott and Robbie Scott on the same day to either set a trial date or enter a plea. Could we set this case for June the 16th in Cumberland County because Ms. McCauley has a conflict on the Clinton motion? And I'll try to get Mr. Acton to change his date to Cumberland County so we can have both of them at the same time.
Do you want them to be available for a conference before then?
There's no need. I've tendered offers. We'll either enter a plea next time or we'll give a trial date.
What's the date? What's the date?
16th, I'm sorry, not the Cumberland County day, the Monroe County day.
What's the date?
June 16th.
Yeah, you were breaking up on.
Okay,
June
June 16th.
16th. You'd be at Monroe Circuit Court on June 16th at 9 a.m.
Thank you, Judge.
Joseph Wallace. Mr. Cross still there? Where's your client, Mr. Cross?
Your Honor, my client remains in rehab, and Mr. Stock and I have agreed to pass this one out another, 1 month or 2, man? Which one? 2 months. 2 months.
What is the July rule day again?
14th.
July 14th.
Thank you.
Yeah. Okay, let's go to Leslie County. Are you on the line? Is Leslie County on the line?
Yes, sir, Your Honor.
Okay, thank you very much. This is Commonwealth Kentucky versus Bobby Phillips, 21 CR 00110. Are you Bobby Phillips?
Yes, Your Honor.
We're here today for a pretrial conference. Who are you represented by? Department of Public Advocacy?
Yes, sir, Judge. I have Mr. Phillips.
Okay, are you on screen?
Yes, he's on there.
Okay. Okay. What do we got, Mr. Stockton?
Your Honor, this is an assault first case where Mr. Phillips allegedly shot someone else. I'm asking Mr. Phillips is currently serving a 12-year sentence. And I mentioned to Mr. Sheffett, and I think he's in agreement. I would like to mediate this case if we could.
That's correct, Judge. I think this would be a proper case for mediation.
Okay, send me an order.
Okay, thank you, Your Honor.
Leslie County, thank you for your cooperation.
Thank you all, Your Honor.
Excused. Have a great day. Roeder Correctional Complex.
I don't see them on, Judge, but they're not scheduled for 5 more minutes.
Okay. Russell County,
That's the same. We have Wayne, it looks like, it's all.
so nobody else is on yet?
Wayne,
Wayne County, okay. Well, watch for those others to come up. I can't see them on mine. And when they do, stop me and I'll go to they just got one case each, okay?
okay.
Let's go to Wayne County. Wayne County.
Yes,
Brandy Beatty.
I have the males up here first.
Okay. Stanley Katrin. Commonwealth versus Stanley Katrin, 21 CR 00120 and 21 CR 0084. Are you Stanley Katrin?
Yes, sir.
Born in 1982.
Yes.
What are the last four digits of your social security number?
1354.
Mr. Stockton, what do you have?
Your Honor, he has two cases. One is a motion to revoke. He absconded and left treatment. The other one is 21 CR 120, which is an arraignment. I'd ask that he be arraigned, and then we set this for May 31st to see if we can do a global settlement.
Okay, it had probation revocation on 21 CR 00120. So okay, that's just a mess.
I don't think he's been arraigned on it. I may be wrong.
No, I don't believe he has, Jesse.
Okay. Mr. Katrin, the grand jury of Clinton County has returned an indictment in 21? Why wouldn't he been indicted in 21?
He hasn't been, Judge. I don't know.
This was one of those trafficking cases that.
Okay. 21 CR 00120. The grand jury of Clinton County has returned an indictment charging you with Megan.
Trafficking in a controlled substance in the first degree, first offense, class D felony.
You understand that charge, Mr. Okay. You want to set this thing for on May the 31st for negotiation, and then June the 9th. Mr. Stockton.
Yes, Your Honor, that's fine.
Okay. William Perdue.
We don't have William Perdue, Your Honor.
He's at Russell.
Okay, move him to that docket. Chris Sanders. Is Chris Sanders there?
Yes.
Okay. Commonwealth versus. Yeah.
On this case, there's a Cumberland County case also. There's two separate sentencings with two separate pleas. They don't encompass each other.
Okay. Are you Chris Sanders?
Yes.
Born in 1985.
Yes.
Last four digits of social security number of what?
3154.
You're here today for the purpose of sentencing. Do you understand that?
Yes.
Have you had an opportunity to look at the pre-sentence investigation reports?
Yes.
Facing parole, are they substantially correct?
Yes, I was just wondering about the charges I had pending. It said
Is your attorney present?
Yes.
Who DPA representing you?
Yes, Judge.
What kind of questions does he have?
I think he was questioning some of the charges listed in the PSI that were pending, which were the Cumberland, looks like to me, the Cumberland and information that we just did, as well as the Clinton. And he has a Wayne County indictment pending as well.
It's supposed to be in on this too.
What'd you say, Mr. Sanders?
And I talked to them too. It was running with this too.
Okay, well, that just may not, the paperwork may not have caught up yet. And the PSI, that's just a listing of charges. That has no official bearing on the actual, what happens with the actual charges.
Well, that'd have to be done in Wayne Circuit anyway.
All right.
I have Clinton and Cumberland, so I've got two. So you have reviewed these documents?
Yeah.
Okay. Is there any reason that this gentleman should not be sentenced?
No, Your Honor.
Okay, this is the Clinton Circuit Court case that I'm going to do first. On a plea of guilty to trafficking in first degree, he shall receive a sentence of 6 years to serve. The sentence shall run concurrently with Cumberland Circuit Court case 22 CR 0031. Agrees to forfeiture the $600. And I'll combine the court cost in the two cases. This is Cumberland Circuit Court case, and it is 22 CR 0031. Upon a plea of guilty to trafficking in controlled substance, first degree, he shall receive a sentence of 6 years. It shall run concurrently with Clinton Circuit Court 21 CR 00160. Forfeit to police radio, to the sheriff's department. I really can't split the costs because they're in two counties. What are the costs in Clinton County?
$155.
Yeah, I'm going to say that's what it is in both counties. And I'll get, when you are released, you start paying $25 to each county a month, 30 days after your release. Okay, $155 in each county. Okay, thank you very much. Okay, are you ready for the females here in a second? Do you have any other males there?
Yes, we have one, William Thrasher, or Matthew Thrasher.
Okay. Oh, I see him here. It was a Cumberland County case, probably. Is that right? No. Commonwealth, Kentucky versus Matthew Thrasher. 22 CR 0032. Is this a Cumberland? Is this a Clinton County case?
Yes, it's Clinton.
Oh, the Cumberland was pointing up above on my. I understand it now. Are you Matthew Thrasher?
Yes, Your Honor.
Born in 1988.
Yes, Your Honor.
Last 4 digits, Social Security number 2239.
Yes, Your Honor.
Okay, we're here for arraignment. You have a right to remain silent. Are you represented by a lawyer?
Yes, Your Honor.
Who represents you?
I've got this case, Judge.
Okay. The grand jury of Clinton County has returned an indictment charging you with the following charges. Megan?
Possession of a controlled substance in the first degree, methamphetamine, and possession of drug paraphernalia.
You understand those charges, Mr. Thrasher?
Yes, Your Honor.
Okay. You'll be present May 31st for negotiations in June. Is it 9th?
Yes.
June the 9th. And what's Mr. Thrasher's bond?
It's a $50,000 property bond. He did have a parole holder holding him.
Yeah.
Judge, we're hoping that his parole hold is going to clear up sooner rather than later. Would the court consider a surety bond?
Well, once that happens, I'll review the thing. I guess I left the $50,000 on there is because he had that parole holder. But I'll review it. Mr. Stockton, what do you think about it?
That's fine. He's got a possession case here. Whatever the court wants to say, it's fine with me on this case. Yeah.
Okay.
No, Mr. Thrasher, he's not going anywhere. He's
Okay,
not a flight risk.
$15,000 sure with curfew, home, church, doctor, work. Clerk approved surety. Okay. He's to be back. We set him for the 31st and the 9th, correct? Okay. Thank you.
Thank you, Your Honor.
Yeah. Do the female prisoners now. Thank you. Miss Megan, anybody else online?
Russell County's online.
Okay. We'll get to them. We got 3 here, 3 or 4 here. We'll get to Russell County. Russell County just got 1. I'm going to do 1 in Russell County office. Russell County, top. Russell County. Russell County. I guess we'll have to turn that Wayne County camera off to get Russell County.
Russell County has to turn the video on.
Okay, well, I guess both of them would help, but Russell County, turn your video on. Russell County. Russell County. Okay, let's go back to Wayne County. Somebody needs to call Russell County Jail.
We're here, Your Honor, but I don't have a list of who you need.
I have one person.
Okay.
Rebecca Major.
And
She is not in our facility.
You can add Willie Perdue to that list, Judge.
Okay, I've got him, but Rebecca is in Madison County for court.
No.
Yes, sir. They picked her up yesterday.
Can you pick up, is Willie Perdue, can he come up there?
Give me just a moment and I'll have him right here.
Okay. What docket do we have him on, Megan?
I think he was on Wayne.
No. Yeah, there he is. Yeah, we called him a few minutes ago. But we'll need to reset Miss Major for next court date, okay?
Is Harmon even playing basketball anywhere?
Been trying to keep up with you. Just hanging out. He's got to get some mental health treatment. In the right environment, he could help somebody. I don't know if he can handle a lot of distractions. Moving around 5 times in 6 years didn't help
It was
him.
ridiculous. It's crazy.
Yeah.
He went from
Y'all's mics on there, guys.
he went from
Let's go back to Wayne. Let's go back to Wayne County.
Russell's on now, Judge.
Okay, let's go to Russell then. Russell County, turn your camera on.
They're on.
Commonwealth versus William Perdue. 21 CR 00130. Excuse me. Mr. Perdue?
Sure.
Were you born in 1971? Were you born in 1971?
Yes, sir.
Last 4 digits of your social security number.
571.
Okay. We're here for a pretrial conference. Mr. Sheffield, is this your client?
Yes, Judge. We have a felony plea for the court to consider.
A motion has been tendered that says you wish to enter a plea. Is that correct, sir?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
You're going to have to speak up.
No, sir.
It's microphone activated cameras. Reason I'm asking you to speak up. Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictment?
Yes, sir.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Before I can accept a plea, I need to know that you understand your rights under the Kentucky United States Constitution. At the end of this list, I'll ask you if you understand. You have a right not to testify against yourself. No one will make you say anything. You have a right to speed trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting a recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation in this case?
It is upon a plea of guilty to trafficking in a controlled substance first degree, the defendant shall receive a sentence of 1 year to serve. The Commonwealth will oppose probation. This sentence shall run concurrently where Mr. Perdue's a state inmate, Clinton Circuit Court, case number 15 CR3. All evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yes, sir.
You realize that this could be used to enhance any future felonies you have. You understand that?
I do, sir.
Okay. Is that your signature on the document? Hold the document up, Mr.
Judge, the paperwork's in the court file.
Okay. Well, hold it up in front of the court thing there. Somebody tap that microphone in there and hold it up. Brother Can.
You have to give me a minute, Judge.
Okay. Is that your signature, sir?
It is, sir.
I'll accept the plea order. Now, is he a state prisoner?
He is, Judge, and we would ask the court to waive separate sentencing.
I'll waive pre-sentence investigation report. Go ahead and enter the judgment. Okay, thank you very much. Now, Wayne County, that finishes Russell County. You're excused. Thank you very much.
Thanks, sir. And I hope you get feeling better.
Thank you. Thank you very much. Wayne County.
Yes.
Brandy. Commonwealth versus Brandy Beatty. 21 CR 0018. Are you Brandy Beatty?
Yes, sir.
Were you born in 1985?
Yes, sir.
What are the last four digits of your social security number?
9531.
Okay, you're here today for a pretrial conference, Mr. Stockton. What do we have?
Your Honor, she has a motion to revoke. She was left rehab on January 31st, 22. It's a 5-year sentence against advice. She was picked up on March 24th, 22 by the Clinton County Sheriff in this case.
And I think we have an agreement, don't we, Mr. Stockton?
Well, Your Honor, I was intent on sending her to prison. I spoke to her father. He has an autistic child that he needs help with. He's not in good health. Miss be candid, Miss Beatty's really never done anything she's supposed to since she's been on probation. She wrote me a letter saying she'd change her ways. I don't know if she will or not, but I'm willing, if you want to, I'm willing under the conditions in lieu of revocation to put her in SAP IOP, do 60 days home incarceration, and as a condition of her probation, she used to get a job and maintain employment. If the court wants to go along with that. If not, we'll proceed.
What do you have to say, Miss Brady? Miss Beatty?
Yes, sir.
Huh?
I will go along with that, sir.
Well, I'm sure you will, but why should I believe you'll do it? Did you ever hear about the guy that stole your dog and promised he was going to bring it back? They said anybody who steal your dog will lie to you about whether they're going to bring it back or not.
No, not that one, but
Yeah. Well, you understand the theory behind it, don't you?
yes.
So you're making a commitment to follow through on this, correct?
Yes, sir.
I'll sign the order, but
Your Honor, I'd ask that this be reviewed June the 9th or July, and we'll see if she's doing what she's supposed to or not.
put you on the docket on June the 9th. Last chance, ma'am. Good luck.
Thank you.
Deborah Bale. Commonwealth versus Deborah Bale, 21 CR 00116. Miss Bale, were you born in 1970?
Yes.
What are the last four digits of your social security number?
1448.
You're here today for the purpose of sentencing. You understand that?
Yes.
Have you had an opportunity to look at the pre-sentence investigation report?
Yes.
Is it correct?
Yeah.
Substantially. Counsel, is there any reason that this lady should not be sentenced?
No, Your Honor.
Upon a plea of guilty traffic control substance first degree, she shall receive a sentence of 1 year to serve. This 1 year shall run consecutively to Clinton indictment number 19 CR 0057. The defendant stipulates the revocation on 19 CR 7. What is the court cost involved in this court?
$155.
155. Well, I'll merge the cases. So you need to pay $155, and I'll give you 30 days to start paying $30 a month. Okay.
Okay.
Okay. Good luck
When do
to
I
you.
start?
Do what?
When do I start paying?
30 days after you get out of jail. I felt like you probably need a little time, won't you? Can you pay 30 a month?
Yeah.
Okay. Well, I don't want to make any sense to anybody something they can't do. You know what I mean?
Yeah.
Okay. Good luck to you.
Huh.
Tanya can answer. Kentucky versus Tanya can answer. 21 CR 00121, 12 CR 00077, 13 CR 00012, and 13 CR 0014. Are you Tanya can answer?
Yes, Your Honor.
Okay. Mr. Stockton, what do you have here?
We have a felony plea, Your Honor.
A motion has been tendered to decision.
Judge, before we get too far into it, I thought we did have an agreement. We haven't gotten the paperwork back from the jail. I don't know whether that's because the defendant has had a change of heart or whether there's been issues in getting the paperwork back to the courthouse.
I just didn't really understand all of it. I didn't know if my time counted from my very first day in 2013 to 2018.
We will put this off then until June the 9th. Okay. Mr. Fine, explain it to her.
I'll talk to her.
Cross, which of you handling this? Mr. Cross, you've got the revocations, right?
I do, Your Honor, and I had understood that there was a deal made, but Tanya has called. So Tanya, I'll come up and see you and talk with you about the plea too, if that'll. Okay.
Yeah.
Stephanie Edwards.
Thank you, Your Honor.
Thank you. Stephanie Edwards.
Yes, Your Honor.
Commonwealth versus Stephanie Edwards, 21 CR 0074. Are you Stephanie Edwards?
Yes, Your Honor.
Okay, what's your year of birth?
83.
Okay, and the last four digits number.
3473.
Okay, you're here today. 21 CR 0074, probation revocation. Mr. Stockton, what do you have?
Your Honor, this is a case where Miss Edwards had 5 years on criminal possession of a forged instrument. She actually cashed a check at City Mart. It's about $2,500. She's not paid much restitution on that. She's also had multiple positive tests for methamphetamine. I would ask that she stay in custody because she owes so much restitution until she's assessed and can enter and complete drug court if she wants to do that. Otherwise, I'd ask that she be revoked.
Counselor, what do you have to say?
And Judge, we have no objection. Either the Commonwealth or myself will submit a referral order today.
We'll submit one, Your Honor.
Your Honor, Your Honor, can I speak?
I don't, probably not. You know, you need to, what's it about?
I have employment lined up for Monday where I can get out and pay. And I also have a child support obligation that I have currently kind of held up that I need to get started paying again too. I would love to do IOP or random drug testing. I don't want to do any more drugs at all. I wanted.
Well, it's either drug court or nothing as far as I'm concerned, and we'll have to have her assessed and get out in orientation because she needs the structure if she's going to make this.
Hey, the deal is, do you want to do drug court or not?
Yes, Your Honor.
Okay. Okay,
Thank you.
I'll go ahead and do that. When you want it back in for review?
I think it'd be fine once she's assessed and released. We can just monitor in drug court. I don't think we'll need a review on this.
Okay.
Jesse, I just soon put it on next month, given some difficulty that we've had with.
I agree with Mr. Shefford. It probably should be set for next month. And hopefully the Wayne County Jail will acknowledge that she's there.
Okay.
Cross calls.
We're done? Finished? Thank you.
Yes. Okay. Marcanza Neale. Marzanka Neale, excuse me.
Okay, sir.
Yeah. This is 21 CR 00128. Miss Neale, you born in 1985.
Yes, sir.
What are the last four digits of your social security number?
803.
You're here today for the purpose of sentencing. You understand that?
Yes, Your Honor.
Okay, hold on just a second. Have you had an opportunity to look pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Okay, is it substantially correct?
Yes, Your Honor.
Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason why this lady should not be sentenced today?
Oh, Your Honor.
On a plea of guilty in trafficking and controlled substance first degree first offense, she shall receive 2 years to serve. The 2 years shall run consecutively with Clinton indictment 20 CR 0052. She stipulates revocation in 20 CR 52. What's the court cost? 155?
Yes.
Pay court costs of $155, starting $30 a month upon your release. Okay. You understand that?
Yes, Your Honor.
Okay. Now, Wayne County, does that conclude you?
Yes.
Thanks very much for your cooperation. I know it was a little rough today, but we've got a little extended circumstance.
We got her done. Thank you.
Okay. Okay, let's go to the Clinton County Jail. Taylor County or Roeder never came online, right?
No, I'll check with them.
Okay. Go to Clinton County Jail.
We're here, Your Honor.
Hey, Troy Albertson. Troy. Commonwealth, Kentucky versus Troy Albertson, 22 CR 0019. Are you Troy Albertson?
Yes.
Okay, we're here today. You born in 1969?
Right.
Okay, we're here today on a motion to revoke bond. Mr. Stockton, what do you have?
I'll withdraw the motion to revoke as far as forfeiting the property, Your Honor. But I think he should probably, he didn't appear in court. That's the reason I filed the motion to revoke bond. I think his father had signed a bond for him.
No, it was my brother.
Oh, it was your brother. I'm sorry.
And Judge, Troy has been consistent with staying in contact with me throughout, and there was, he got mixed up on the date for the arraignment. And if you look at the bond paperwork, originally there was another date given, and then it was marked out for April 14th. I don't know when that was done, but.
Oh, all right. You want him in for a negotiation or anything, Mr.?
Yeah, I'd like to have a meeting on the 31st and then court June 9th, Your Honor.
Does he need to be arraigned?
Yes. He's not been arraigned that I know of.
Okay. Mr. Albertson, we're gonna arraign you with your case.
Okay.
Has he got an additional case? How
No, he just has the one case, Your Honor, but he'd never been arraigned. He'd never been in court. That I know of.
Okay. The grand jury of Clinton County has returned an indictment charging you with the following crimes. Megan?
I'm working on getting the file ready.
Okay.
He's charged with theft by unlawful taking or disposition over $1,000.
You understand that charge, sir?
Right.
Okay. Who's your attorney?
I am.
Okay. You acknowledge the identity of your client, receipts indictment, waive formal reading and arraignment, and plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
May 31st and June the 9th.
Judge, I would like to request the court to reset the surety bond. I do think there was confusion. I don't think Mr. Albertson would intentionally miss court dates, and he's a local resident with local ties. He's not a flight risk.
Mr. Albertson?
Yes.
I don't see you. Speak up a little bit there.
Yes, sir.
I've never forgotten a date in my whole life. You believe that?
I'm sure you're not, but I apologize for it.
I'm just saying that in jest. Everybody forgets one sometimes. Okay, so I'm going to believe you. Okay, so I'm going to let you out on that same bond. Okay.
Okay, so am I released?
Well, just as soon as we get the paperwork down there.
Okay.
Probably 2 or 3. You get to eat lunch, probably.
Oh, well, I love that.
Okay.
He just needs to make sure he's here the 31st, Your Honor, too.
May 31st and June 9th.
May 31st and 9th. Okay. Thank you very much.
All right, thanks, sir.
Billy Eminette. Commonwealth, Kentucky. Billy Eminette, 21 CR 0037. Are you Billy Eminette?
Yes, sir.
Judge, although David Cross's office, still in for Mr. Cross.
Here today for the purpose of you understand?
Yes, sir.
Have you had an opportunity to look at the police investigation report done by probation and parole?
Yes, sir.
It's right here.
Yes.
You find it to be substantially correct?
Yes, sir. Besides some of the dates on my house arrest and stuff wasn't counted in there.
What is did you have an ankle bracelet on?
Yes, sir.
Probation and parole, did you hear that?
Yes, Your Honor.
Could you check into that for this gentleman?
Yes, Your Honor.
Okay.
No, also there's some days it was in district court, wasn't counted too.
Okay, we'll check on that also, okay?
Okay, thank you.
Yeah. Upon a plea of guilty. So, upon a plea of guilty and indictment number 21 CR 0085, where the charge of lawful taking over 500, he shall receive a sentence of 4 years to serve. Penalty of $30, subject to 5% clerk's fee. Shall pay the cost of is it 155?
Yes.
Yeah, I'll give you, when you get out, you can start paying that at $30 a month, okay?
Thank you, sir.
Okay. That'll do it.
Thank you.
Billy Brown. Billy Brown.
Judge, we've got Taylor County on there when we get a chance.
Okay, let's fly over to Taylor County. They just got one. Billy, I'll be right back. Okay. Taylor County Jail, turn your camera on.
Yes, Your Honor.
Thank you very much. Commonwealth Kentucky versus Jesse Brown, 21 CR 0005. Are you Jesse Brown?
Yes.
Are your year of birth 1989?
Yes.
Last four digits of your social security number?
8111.
Okay, you're here today for a pretrial conference in 21 CR 0005. What does the Commonwealth have to say? Mr. Stockton? Mr. Stockton?
Yeah, my battery's running low. It's having a little problem there. Yeah, it's for sentencing, Your Honor.
Oh, it had a pretrial conference on here. Okay.
Your Honor, originally it was, and then you allowed us to enter the plea last week at mediation for Mr. Brown, and probation and parole managed to get us in for sentencing this week.
Mr. Brown, you had not viewed the pre-sentence investigation report of a parole. Mr. Brown, have I lost Taylor County?
No, I'm here.
Okay, have you had an opportunity to review this pre-sentence investigation report?
Yes. Yes.
Is it substantially correct?
Yes.
Okay. Counselor, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
Upon a plea of guilty to murder, the defendant shall receive a sentence of 25 years to serve. Upon a plea of guilty to wanton endangerment, 3 counts, he shall receive a sentence of 5 years to run consecutively 15. However, the 25-year and the 15 years are to run consecutively, a total of 40 to serve. Upon a plea of guilty to operating a vehicle on or above 0.08 or while the influence, he shall pay $200 fine. I will waive the court costs. Okay, I will sign the judgment today. Thank you very much.
Thank you, Your Honor.
Thank you, Taylor County, for your cooperation.
Yes, sir. Thank you, Your Honor.
Let's go back to Clinton County. Billy Brown. Commonwealth versus Billy Brown. Billy?
Yes,
Okay.
I'm here.
Okay, let's get started with your thing. This is 22 CR 0020. You born in 1968, Billy? You born in 1968?
Yes, sir. I'm sorry, I didn't hear you. It blanked out.
Of your social security number 9932?
Yes.
Okay. We're here today for a pretrial conference. Mr. Stockton. Yeah.
Have a pretrial diversion plea, Your Honor.
Okay. A motion has been tendered that says you wish to enter a plea.
Excuse me?
A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
You the same person named in the indictment?
Yes, sir.
Judgment impaired in any way?
No, sir.
Have you had plenty of time to discuss this matter with your attorney? Feel like
Yes.
you're full? Yeah. Are you satisfied with his advice?
Excuse me?
Satisfied with his advice?
Yes. Yes, I'm sorry, I'm hard of hearing.
Okay, that's okay. You have the certain rights in the Kentucky United States Constitution. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, but right to be represented by counsel at your jury trial, a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand that?
Yes, I do. Yes.
Okay, you understand me entering that you waive those, right? I may look at the Commonwealth's recommendations and prove them, but I may reject them. And if I reject them, you have a right to withdraw your plea and go to trial. You understand that?
Yes.
Okay, have you previously been diverted in the last 5 years?
No, sir.
You have any felony convictions in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you complete the diversion program, that your charges will be dismissed, pretrial diverted, and you will not be a convicted felon. You can get them expunged. You understand that?
Yes, sir.
But if you do not successfully complete the diversion program, you come back in front of me, I will schedule a sentencing hearing. You'll be a convicted felon, and that can be used in the future against you. You understand that?
Yes, I do.
It is a Commonwealth's recommendation.
Yes.
Mr. Stockton.
Your Honor, Mr. Brown would plead to trafficking in a controlled substance first degree, 2 counts, have a sentence of 3 years, pretrial diverted for 5 years. He'd enter and complete the Clinton Specialty Program, receive credit for time served, pay court costs at the discretion of the court, maintain gain of 1 point.
Is that what you agree, sir?
Yes, I think so. Yes.
Okay. Are you pleading guilty because you are guilty?
Yes.
Okay.
Yes,
Knowing your constitutional rights, is it still your desire to enter this plea and allow me to fix the punishment?
Yes, sir.
Okay. Now somebody hold that document up to him there and let him see it. See if it's signature. They'll
Yes.
hold it. They'll hold
Yes.
it up. Can
Yes,
you see? Okay.
Yes, sir.
Your signature. Okay. Okay. I'll sign the documents today. Okay. Thank you very much. Benjamin Clay.
Hey, Judge and Mr. Stockton, regarding Billy Brown, there's a drug court assessment order, either may have already been tendered, but there's also one in the paperwork I have. And he's getting a diversion with credit for time served. I would request that he be released. I have a phone number for the drug court to contact him.
I just hate to start doing that, Your Honor. We've always kept people in custody so they get oriented.
I'm not starting it. No. Benjamin Clable. Commonwealth versus Benjamin. CR 0088 and 20 or 0089. Mr. Clay, were you born in 1986?
Yes, sir.
Last 4 digits of your social security number.
2415.
Have you had an opportunity to look at the pre-sentence investigation reports done in your cases with your attorney? Okay, are they correct? They correct essentially?
Yes, sir.
Okay. Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Okay. Found guilty under indictment number 21 CR 0088 for charge of fleeing and evading police. The defendant shall receive a sentence of 10 years upon a plea of guilty to 21 under 21 CR 0089 for possession of a handgun, but convicted felon 10 years upon a plea of guilty. Indictment number 21 CR 0089 for trafficking and controlled substance for security shall receive 10 years. The two concurrently for a total of 10 years. 10 years sentence in 21 CR 88 and the 10-year sentences in 21 CR 0089 shall run consecutively for a total of 20 years with a balance probated for 5 years supervised. He shall enter and complete the specialty court. Now, I would suppose that this other pre-sentence investigation report is no, there's 2 pre-sentence investigation reports. Okay, thank you much. What were the court costs in that? 155?
Yes.
Court cost of $155, sir. I'll give you need some time to pay that since you've been in jail for a little while. Okay, I'll let you start paying that. In 30 days, you can start paying $30 a month. Can you handle that?
Yes, sir.
Okay. Hope things turn around for you, man.
All right. Thank you, Judge. Thank you, Jesse.
Yeah. Luther Connor. Commonwealth versus Luther Connor, 22 CR 029. We're here today for the purpose of arraignment. Mr. Connor, what year were you born?
2002.
And what are the last 4 digits of social security number?
0424.
Okay. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with the following charges, Megan.
Possession of a controlled substance in the first degree methamphetamine.
You understand that charge?
Yes, sir.
Okay. Who has this case?
I do, Your Honor.
Okay. Hold on just a second. I've got a battery problem here. Needed something else here.
Melissa.
I'm having trouble getting back on. I'm sorry. Megan, I'm going to have to check back in, okay?
Okay.
Okay, we're back on here. What's Mr. Connor needs to be there for negotiations on May the 31st, and then next court date's June 9th. What is his bond?
He has a surety bond, but he has some holders as well.
What kind of holders is he have?
Is there a drug court holder or something like that?
I don't know. Mr. Stockton, do you know what kind of holder he has?
I believe it was for not appearing in drug court when he was supposed to. I'm just going by memory. It's been last Monday. And so
Okay,
he'll be
well,
taken
y'all-
up next month now that he's in custody. He's not been terminated yet that I know of.
Okay, well, we'll just take a look at that and y'all can discuss what his bond is when you find out more about it, okay? And then get back with me. Joey Garrett. Joey Garrett.
On this mediation order, I don't do anything until you all give me a date, correct?
Commonwealth versus Joey Garrett. 20-009. Okay, somebody, you need to quieten down there at the jail a little bit, okay? Thank you. Mr. Garrett, were you born in 1979?
Yes, Your Honor.
What are the last four digits of your social security number?
5099.
Okay, you're here today for a probation revocation in 20 CR 009. Mr. Stockton, what do you have?
Your Honor, he was had a 5-year sentence trafficking case in Kentucky. He was transferred to Tennessee, and he had a DUI conviction down there. I think between Kentucky and Tennessee, he served about 90 days in jail. Tennessee is requesting revocation on this case. And Mr. Cross represents him, and I don't see him on the computer anywhere.
Mr. Cross? Can anybody look around, see if they can find Mr. Cross?
He's back there. I think you sent him.
He's back with Brad, so he
There
just,
we go. Thank you, Brad. I'm not too smart about this modern stuff, Your Honor, as you know.
Joey Garrett is on the line here on a probation revocation. Mr. Stockton, make your statement again.
Yeah,
I
Mr.
heard him, Your
Garrett.
Honor.
Okay, go ahead.
Yeah. Your Honor, may I address the court and Mr. Stockton?
Sure.
Your Honor, I represented Mr. Garrett when he was first charged and made a plea agreement. He went for 1 year to the Teen Challenge Rehab in Dixon, Kentucky, and according to all concerned, got along very well for an extended period of time. He, however, fell under the influence of a young lady of questionable character, according to his father. They got involved in an argument, and Mr. Garrett was arrested for DUI in the driveway of his home. And I would note that the only accusation was use of alcohol and not drugs. It sounds like the sort of case I wish it had been in Clinton County, where we might have had some ability to offer him a better defense. All that being said, Mr. Garrett has been in jail now for his Tennessee time plus about a month of Kentucky time. He did really well, and he talks really good right now that he's refocused. He's got tremendous family support. Within the courtroom is his father, who's a county commissioner in Pickett County, his grandmother, and his aunt, I believe it, nor his sister. And I've made the following proposition to Mr. Stockton and to the court, that Mr. Garrett return to the rehab where he was previous, and that when he is discharged from there, since Tennessee apparently doesn't want to fool with him anymore, he would be living and residing with Kathy Daniel in Clinton County. Her husband, Wayne Daniel, is an extremely well-respected member of our community. And that way Pickett County wouldn't have to fool with him. And he would remain with her so long as he was under, well, so long as they wanted him to reporting status or whatever. But the only bauble, if you'll look at the report, the only bauble, as Perry Cross used to say, is this DUI. He had nothing else for a year. I know this court takes a dim view of those, but the fact that it was alcohol within his driveway, I think that mitigates it to a certain extent. And I don't think Mr. Stockton's opposed to my proposal if it's all right with the court.
I would just say, Your Honor, I would be in agreement if it's all right with the court. I think he's going to be at Team Challenge for a year in Dixon. Is that correct?
Well, they have their basic program is a year. The fact that he's already done a year, I suspect they may not require him to do the entire time, but that's up to them.
And I just would say if he's going to be living as a requirement with Wayne and Kathy Daniel, I know he's either going to fly right or he won't be there long.
That's true.
Mr. Garrett, you'll say something?
Yes, sir, Your Honor.
Tell me something.
Your Honor, Mr. Cross spoke true of circumstances, and he spoke true about my time at Team Challenge. It was a learning experience and growing experience, and again, I just fell on my face one more time, and I would ask the court, please give me this opportunity. I have custody of my young son, my grandparent or his grandparents are raising at this moment, and I would love to be in his life. I worked a full year, had a good job up until the day I went to court and was revoked. They'd probably hire me back today, but I think they said,
if you can't get a job now, it's only because you don't want one. A lot of people hiring. Okay, well, you've convinced me. Well, you've convinced me. I'm gonna give you one, but I'm gonna tell you, don't you be around driving any vehicles with any liquor or beer on you now. That's a bad thing. You're one of the few people I've not revoked for that, but at least one of the reasons is you've been trying to work and stuff. Okay?
Yes, Your Honor.
I'll draw an order, Your Honor.
Okay. Giordano or Gerger? Gerardina Gerger. I'd be interested. I don't know how. How do you pronounce your first name, sir?
Ferdinand.
Ferdinand with a G?
Yes. No, F-E-R-E-I.
Okay, there was a mistype on my docket here, and I was having trouble with it. Okay. Ferdinand Gerger, which is 21 CR 009C. What, Mr. Gerger, were you born in 1968?
1958.
1958. Well, you've already lost 10 years here. You hadn't been here. And what are the last four digits of your social security number? 5474?
Yes.
Okay, you're here for the purpose of arraignment. You have the right to remain silent. Are you represented by an attorney?
Yes.
Judge.
Mr. Sheffield, was he one of yours?
Yes.
The grand jury of Clinton County has returned an indictment, sir, charging you with, and Megan, will you?
Possession of a controlled substance in the first degree methamphetamine and possession of drug paraphernalia.
You understand that charge?
Yes, I do.
Okay. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, what kind of bond is Mr. Ferdinand Gerger under?
He has a clerk approved surety. Did he have to be extradited, Jesse?
I don't know. He's been in NCIC since September 22nd. My staff tells me we did have to extradite him. We're from.
Okay, well, y'all work on that with counsel.
We should be able to resolve it pretty quick. If not, we can give him a speedy trial.
Judge, I would, he does have local ties and a local residence.
Well, y'all work it out and get back with me. Okay? And if y'all get back with me, if you want to hear it, I'll set you one, okay? Sherman Hensley. Sherman Hensley. Commonwealth versus Sherman Hensley, 21 CR 0090. Correct that. 21 CR 0027 and 21 CR 0038. We're here for the purpose of sentencing. Is that correct?
That's correct, Your Honor.
Okay. Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
I have, Your Honor, and provided that to Mr. Hensley.
I'm asking Mr. Hensley if he has.
Yes, sir.
Okay, is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced?
There is not, Your Honor. The only thing that I would point out to the court is on the PSI, it incorrectly states on the first page that, or on the, when it states the agreed penalty and sentence, that Mr. Hensley was to complete long-term rehab. After talking with with Commonwealth Attorney, we had, and that is reflected in our paperwork, that it was to be drug court, not long-term rehab. And he, in fact, has begun attending the Clinton County Drug Court.
You agree with that, Mr. Stockton?
I do, Your Honor.
Okay, upon a plea of guilty and indictment number 21 CR 0038 for the charge of trafficking controlled substance first degree, he shall receive a sentence of 10 years. Upon a plea of guilty in 21 CR 0027 for the charge of possession of controlled substance, he shall receive a sentence of 3 years. The 10-year sentences in 38 and 27 shall run currently for a total of 10 years. Agrees to shock probation after he serves 120 days in jail. He shall enter and complete the Clinton County Specialty Court program. He shall receive credit for time served. Court costs in 2 cases to be merged, $155. He will pay that starting $30 a month, 30 days from today. Okay. Thank you. John Luttrell.
Thank you.
John Luttrell. Commonwealth Kentucky versus John Luttrell, 21 CR 00126. Are you John Luttrell?
Yes, sir.
Are you born in 1970?
Yes, sir.
Last 4 digits of social security number are 5446. Is that correct?
Yes, sir.
Your pretrial conference on 21 CR 00126. What do you have to say, Mr. Stockton?
We have a misdemeanor plea in this one, Your Honor.
Okay. Motion been tendered, says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
You have certain rights under the Kentucky and the United States Constitution. Before I can accept it, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering this guilty plea today, you give up all those rights. Now, this is a misdemeanor plea, but you still have to acknowledge you understand those rights you have, okay?
Yes, sir.
Okay, Mr. Stockton, will you go ahead and recite the plea agreement?
Yeah, Mr. Luttrell will plead guilty to criminal attempt to traffic in controlled substance first degree, a class A misdemeanor, be probated for 2 years, supervised. He'd receive credit for time served, remain on active supervision. pay court costs at the discretion of the court. All evidence be destroyed.
What is the sentence?
It's 12 months.
Okay, 12 months. You just left that part of it out.
I
didn't know.
apologize.
Okay, is that what you agreed to, sir?
Yes, sir.
Okay, court costs amount of $155. I'll let you pay that $30 a month, starting 30 days from today, okay?
Yes, sir.
Need to meet with the probation parole officer over there. All right. Thank you. Cody, he'll be out to see you. Cody Owens. Cody Owens.
You do Daniel Norman. I know this.
Cody Owens. Cody, are you there?
Yes, sir, Your Honor.
Commonwealth versus Cody Owens, 21 CR 0031. Cody, you're here for arraignment in 21 CR 0031. Were you born in 1987?
Yes, sir, Your Honor.
What are the last four digits of your social security number?
351.
Excuse me. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with Megan.
Criminal trespass, 3rd degree, burglary in the 2nd degree, and criminal mischief in the 3rd degree.
You represented by counsel?
Yes, Judge.
You acknowledge the identity of your client received indictment, waive formal reading and arraignment, and your plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Set this for negotiations on May the 31 and next court date, June the 9th. What's this gentleman's condition as far as his bond is concerned?
$50,000 property bond. He's also serving some county time, and he has a Wayne indictment holding him.
Okay, well, if those things get resolved, we'll reconsider it then.
Your Honor.
Yeah.
Your Honor, I went to Wayne County Court last week, and they agreed to send me to long-term rehabilitation. If you would agree to send me the county time, also would agree to send me to long-term rehabilitation. I know I'm at the mercy of the court, Your Honor.
Well, what you need to do is discuss that with your attorney. I'm not necessarily opposed to that. And
that'll have to be something that's negotiated, something we'll talk about on May 31st, be my guess.
Yeah, okay. That'll be okay. Thank you.
Thank you.
Timothy Perrigen.
I'm sorry, who'd you say, Your Honor?
Timothy Perrigen.
Yes, sir.
Okay, Commonwealth Kentucky versus Timothy Perrigen, 17 CR 0033 and 17 CR 0042 rather. Can you hear me?
Whatever, I can hear you out this one.
Okay. You're here on a probation revocation charge.
Yes, sir. Messed up again.
Mr.
Judge,
Stockton.
we would be stipulating to the violations.
Okay, what do you have to say, Mr. Stockton?
Yeah, it's an altered. He has a 3-year sentence on trafficking. It's an altered attempted evasion of a drug test. And he said he'd just rather serve his time. So we'll do an order if that's all right with the court.
That's fine. Okay. Hope it turns around for you, Mr. Perrigen.
I'm trying. I thank y'all for all y'all trying to help me, you know.
Okay. Good luck to you. Commonwealth versus Michael Richie.
Richie.
Commonwealth versus Michael Richie, 22 CR 0015. Are you Michael Richie?
Yes, sir.
You born in 1973?
Yes.
Last 4 digits, your social security number 4878?
Yes.
Okay. You're here today for a pretrial conference in 22 CR 0015. Mr. Stockton, what do you have to say?
We have a pretrial diversion plea, Your Honor.
Okay. A motion's been tendered that says you wish to enter a plea of guilty today. Is that correct?
Yes.
Are you currently under the influence of drug or alcohol?
No.
Is this plea you voluntarily given?
Yes.
Have you had plenty of time to discuss these matters and look at all the evidence? You feel like you're fully informed about your case?
Yes.
Okay. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, your right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. Yes. Now, they consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. In the event I do not accept the recommendation and decide to impose a harsher sentence on you, you have the right to withdraw your plea. Your trial. Now, have you been previously diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand that if you complete the diversion program, the charge against you will be dismissed, pretrial diverted, and you can have them expunged. You understand that?
Yes.
Okay, you understand that if you not fully complete the program, you'll be brought back before the court. We'll schedule a hearing. And if I find that you violate the terms, I'll get a pre-sentence investigation report. You'll be a convicted felon. That could be used against you in the future. You understand that?
Yes.
Stockton, you agree to the recommendation?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years, supervised. The defendant shall be referred to the SSC and follow all recommendations of the commission. You'll also obtain anger management and mental health assessment scheduled through probation parole. Both anger management and mental health assessments shall be submitted to the Commonwealth and Defense Council. The defendant shall comply with requirements of any EPO or DVO entered by the victim, Melina Richie, in this case. The defendant shall receive credit for time served and shall be released at says final sentencing, but it'd be today since it's a diversion. Pay fine and court costs at discretion of the court. Obtain gainful employment, do a minimum or 30 hours community service, remain on active supervision, and shall forfeit the 9mm pistol that was confiscated, and pay court costs at discretion of the court.
Is that what you agreed to, sir?
Yes, sir.
Court costs are $155. I'll allow you to pay that $30 a month. You can pay the first payment 30 days from today, if that'll help you any.
Yes, thanks.
Yeah, is that your signature on there? Hold that signature up there for him, somebody in front of the camera.
Yes.
Okay. Well, I'll accept the agreement, sign it today. And
all right, thank you.
I hope things turn around for you, man.
All right, thanks, sir.
Timothy Stapp. Commonwealth, Kentucky versus Timothy Stapp, 18 CR 0096. It's got down here. Are you Mr. Stapp?
Yes, sir.
Born in 1988.
Yes, sir.
Last 4 digits, social security number 8048.
Yes, sir.
Okay, what do we have here? It says other hearing, Mr. Stockton.
Your Honor, I have, this is our motion to revoke. I think Mr. Stapp has a 3-year sentence on possession. He left the Hope Center on February 2nd against advice, and he was recently picked up, I think.
Can I say something on my behalf?
Wait just a second. I'll give you a chance. Okay. Counselor, what do you have to say?
Judge, we would stipulate, but I think Tim does want to speak on his behalf and does want to ask the court and the Commonwealth to consider alternatives to revocation.
Okay, I'll let him speak. Go ahead, sir. You have your opportunity.
I know I've made mistakes, and I've made plenty of them in my lifetime. And I'm not trying to, beat around the bush on that. I know I have. And there was more drugs in that rehab than I've seen right here in this county when I was up there. And I asked them to move me where I was at, and they never would do it. I relapsed up there, and I freaked out, And I come home, and I regret it. because I really did like rehab. But almost 4 years ago, I made a promise to you, Judge, Your Honor, and that I would graduate school. And for the last 3.5 years, I've been an AB. My lowest grade was I did fail a couple classes, but I brought my grade up. I'm 7 months for having a degree, and I've worked real hard to get that far. Months, and that don't make anything any better or anything like that. It's just some of my regrets, you know. And I'm just asking, maybe you should give.
Mr. Stockton, you have any suggestions on this?
No, Your Honor, I've dealt with Mr. Stapp for the last several years. We've tried drug court, we've tried rehab. This is a possession case. I hope at some point in his life he doesn't do drugs because I like him. I don't want him to be another statistic. There's more people dying right now of overdoses than any other time because of the fentanyl. And you know,
What is there another rehab? Is there another rehab we can send him to?
Is it possible I could do IOP on the street?
Wait just a second, sir.
Sorry.
Is there another residential rehab that we can send him to?
I'd be up to probation parole. I'm sure there is.
Well, let's search around and see what the deal is. It was started out as a possession case.
He'd be better off just stipulating and getting his time behind him and getting behind it. But if he wants to go to rehab again, I'll be fine with that.
I just want to finish school, Your Honor, and I can't do school.
Here's what he's saying. Is if you just go, how much probation parole, take a look at his chart and see how much time he would have before he'd be parole eligible.
I know that, Your Honor, I know that even at parole eligibility.
Wait just a second. Okay. Is probation parole on the line?
Hey, looking, Judge.
Your Honor.
Yes.
Chris Martin, probation parole. It's hard to specifically say because that's up to the parole board once they review a case.
I asked when he would be eligible.
It'd be looking at
how many days jail credit is that?
Be looking at 15% on a 3-year sentence. So if he stipulated, once paperwork made to Frankfurt and they started reviewing, again, I don't want to say for certain, but probably if not now, based on the roughly 80 days he would have credit for, it would be pretty soon, probably within a month as far as being eligible. Now, if they would give him parole, say that. So,
Well, Judge, if he's revoked, he's got 80 days in. And if he doesn't make parole, we could always shock him into long.
That's what I'm going to do.
It's roughly about 80 days from my quick calculations, Judge. So
Well, he's already parole eligible.
Okay, I'm gonna revoke you, and I'm gonna take a opportunity to see if they parole you. And if they don't, I'm gonna shock probate you with some conditions. Between then and now, we'll find another rehab. Okay.
Thank you.
Okay. Michael Stinson. Michael Stinson. Commonwealth versus Michael Stinson, 22 CR 0027. Are you Michael Stinson?
Yes, sir.
You born in 1976?
Yes, sir.
Last 4 digits of your social security number are 2952.
Yes, sir.
Can y'all see him on the camera all right, or does he need to back up just a little bit? Okay, that's good right there. We're here today for arraignment in 22 CR 0027. The grant, you have a right to remain silent. Who has this case?
I've got him, Judge.
The grand jury of Clinton County has returned an indictment charging you with 22 CR 0020 with the following crimes in 22 CR 0027.
Possession of marijuana and possession of a handgun by a convicted felon.
You understand those charges?
Yes, I do, Your Honor.
Your Honor, we would enter not guilty plea, waive any further formal arraignment on this one, and we have.
You acknowledge the identity of your client, receive indictment, waive formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Judge.
Okay, May the 31st for conference and June the 9th for the next court appearance.
Judge, if we could look at Mr. Stinson's bond, I believe he's also got a pretrial on the docket as well.
What for?
The pretrial isn't on the docket. It was scheduled last month and Mr. Stinson didn't appear and there was a warrant of arrest issued. So there wasn't another court date given for that pretrial.
Okay. Okay. We'll discuss, you can discuss that on May 1st, Doctor. Like
Hang on.
Commonwealth versus Jason Taylor. What we just did. I thought there were two Taylors. There's a Taylor and a trailer, right? Commonwealth Kentucky versus Jason Taylor. 22 CR 0028. We're here for arraignment. Mr. Taylor, were you born in 1980?
Yes, sir.
Last four digits, social security number 2813.
Yes, sir.
We're here for purpose of arraignment. You have a right to remain silent. Whose case is this? Do you have this?
Mine, Judge.
Okay. The grand jury of Clinton County has returned an indictment charging you with, Megan.
Disorderly conduct, second degree, possession of drug paraphernalia, possession of a controlled substance in the first degree methamphetamine, and trafficking in a controlled substance in the first degree, first offense, class C felony.
Okay. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
Pretrial motions. Okay, well, we'll set him as a pretrial conference on May the 31st.
Judge, could we look at his bond?
And then his appearance is June the 9th. Sure. Go ahead.
What's his bond set at?
It's 25,000 cash. He picked up new felony charges whenever he was served with this. It's been waived for the grand jury.
I believe what happened is upon the search, he found he was charged with possession once again. And I think that bond is at a level he can make, but he can't make a large cash bond. We would ask the court for a surety bond on this case.
Y'all can discuss that on May the 31st. Okay, thank you. My position on that is he was out on a bond from district court when, bound to have been, which he violated. David Ray. Commonwealth versus David Ray. David, are you there?
Yes, sir.
Okay, it's a voice activated thing. So this is we're here for are you born in 1975?
Yes, sir.
Last four digits, social security number 7615.
Yes, sir.
Okay, we have a here for arraignment on 22 CR 0030 and for pretrial conference on 22 CR 0011. You have the right to remain silent. Mr. Sheffield, is this one of your clients?
Yes, Judge.
Okay, the grand jury of Clinton County has returned an indictment charging you with Megan.
Possession of a controlled substance, first degree methamphetamine.
Do you understand that charge?
Yes, sir.
You acknowledge the identity client received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
What's this gentleman's bond?
He has a surety on both. I'm going to assume that he probably can't get it approved.
How much is it?
25,000.
What do you know about this, Mr. Stockton? Anything?
Well, the case he was arraigned on, he had meth in his wallet. 22 CR 11, he was charged with promoting. Evidently, he had something on him when he went into the jail, and they confiscated that. Had meth on him then.
Yeah.
So that made him have a PFO. He has a previous manslaughter conviction, I think. I think that was meth related. So I was
Okay, well,
hoping
y'all-
he got out of
y'all
jail
can
on that, he would quit the meth.
Y'all can discuss that on your negotiation date, May 31st, negotiation date, and June the 9th, next court date. Okay, thank you. Now, do we have anybody else at the Clinton County Jail?
We do have Brandon Hall.
I think trailers at Wayne County.
Okay, Megan, who do we have left?
I guess just Brandon Hall, if he is there.
Give me his file, please.
Where did he appear on the docket at?
Very first.
Very first. Very first page, Judge. Very top.
Oh, yeah, the top up there. That's the only thing we've got left?
What'd you do on Jake?
I think so, yes.
Okay.
What's he say?
Commonwealth versus Brandon Hall, 21 CR 00123. Are you Brandon Hall?
Yes, sir.
Okay, were you born in 1982?
Yes, sir.
Last four digits of your social security number.
3773.
Okay, Mr. Stockton, what do we got here in 21 CR 00123?
We have a felony plea, Your Honor.
Okay. A motion has been tendered that says you wish to enter a plea of guilty today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 00123?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney, review the evidence of the case?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial, but jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. The right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I'll await the precinct's investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed. What's the Commonwealth's recommendation?
Your Honor, Mr. Hall would plead guilty to trafficking in a controlled substance, first degree, first offense, receive a sentence of 2 years to serve. The 2-year sentence shall run consecutively with Cumberland indictments number 21 CR 157, 116, 54, and 26, all 21 cases. He'd receive credit for time served, pay fine, court costs at discretion of the court, and all evidence in this case would be destroyed.
Okay, is that what you agreed to, sir?
Yes, sir.
You're pleading guilty because you are guilty for no other reason?
Yes, sir.
Okay. And knowing your constitutional rights, I've explained it's still your desire enter a plea and let me fix your punishment as permitted by law. You understand, by entering this guilty plea, you become it'll count as a felony on any, could be, and your sentences could be enhanced and persistent felony offender law in the future. Somebody hold that document up and show this gentleman his signature.
It's in the court file, Judge. Well, actually, I have it.
Just say something there.
Yes, sir. I see.
That's your signature? Okay.
Yes,
Well, I'll accept the agreement. Now, is he a state prisoner now?
Yes, he is, Judge. We would ask to waive separate sentencing.
Okay, I will waive pre-sentence investigation report, sign the judgment today, okay?
Thanks, sir.
Thank you very much. Now, does that conclude the docket?
Yes, Judge.
Clinton County, thank you for your cooperation.
Yes, sir. Thank you.
I'll hang up off of this. We'll get back. When's the next thing scheduled?
Sir? And I'll be me? No. Right. Brad, we do not have Brandon Hall's paperwork.
I have. Well, it should be in there. I think I put it in there last court day.
And maybe it was behind some of that stuff. As far as the transport order.
I've got a copy of it.
Sorry, something from Daly, or something back. Something from Daly, possibly. I don't know.
Well, yeah, signed it. Never mind. Never mind. I had it the entire time. So. Yeah, that's every once in a while you get caught up in that.
Megan, are you on there?
You ready?
I'm ready. Well, I'm sorry I'm not able to be there with you today, but if I was there with you, y'all all have to go in quarantine because I've got the COVID. Mr. Foreperson, have you finished your work?
Yes.
Okay, would you hand that to the bailiff? And bailiff, would you present it to Megan there? Now, have 9 or more of you signed the documents there on each one of the indictments?
Yes.
Okay. Megan, is there anybody, will you check that there and see if there's anybody that we need to release from bond?
No, you're good.
Okay. Well, I guess the next time we'll see you June the 9th, and I hope I'll be there with you then. You enjoy this beautiful day. Thank you for your work. You're excused. We'll go out. I'll session until 1 o'clock. Okay, we shall come to order.
All right,
Thank you very much.
back in session this afternoon. Honorable David Williams.
Thank you. We'll start on the docket. Van Winkle versus Van Winkle.
Judge, this is a contempt motion, order to pay $207 a month on current, 25 on arrears, and we're asking 400 by 6/8 of 22.
Okay, we'll enter the order. Clinton County Child Support and Others versus Donnie Jones.
We have an agreed order, we're submitting to court on that, Judge.
Okay. Cabinet versus Ken Cross.
Your Honor, in this case, order to pay $292 a month on current, 25 on arrears. We're asking $1,000 be paid by June the 8th.
Okay, sounds reasonable. Melanie Stockton versus Sean Stockton.
Your Honor, we have an agreed order in this case to submit to the court.
Okay. Cabinet versus Wireman.
Judge, we have an agreed order to submit in that case.
Okay. Cabinet versus Phillips.
Judge, we have an agreed order in that case.
Okay. Cabinet versus Cope.
Judge, this is a motion to set child support. If we want to put Kathy under oath for just a minute.
Hey, your right hand, please. You swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Okay.
State your name.
Kathy Harden,
By whom are you employed?
Clinton County Child Support,
What is your position?
caseworker.
Are you familiar in the case of Kentucky Foster Care versus Joseph Cole?
Yes, I am.
And what's your involvement in that case?
We're needing to set child support.
Okay, and have you set the amount in this case?
Yes, we set it by the guidelines, $199 a month, starting May 1st.
Okay, and was Mr. Cole served in this case?
Yes.
Okay,
Yes.
and when was he served?
January 26th, 2022.
Okay, and is this income that you, the amount you set based on the Kentucky Child Support Guidelines?
Yes, it is.
We submitted an order, Judge.
Okay. Cabinet versus King, Benny King.
Your Honor, we have an agreed order to submit to court on that case.
Hey, does that finish your docket?
It does, Judge.
Okay, thank you very much.
Yeah, hope we get the feeling better.
Okay, thank you.
Judge, we're done to 1:30.
Okay. Okay, civil docket. Should come to order. Let's call the first case. Haney versus Haney.
David, we're coming.
There now.
Somebody's got a phone or something they're gonna have to turn off in there. Getting feedback. Haney versus Haney.
Yes, Your Honor.
Somebody's got something they've got to turn off. We're getting feedback. Turn the camera on in the courtroom. Somebody stand in front of the bench there and see if you can voice activate. Just say something so I don't know whether it's going to work or not.
Testing. Yeah, I can hear it. Hello.
Melissa?
Yes.
There's a problem there. Somebody's got something turned on that has to be turned off. We're getting feedback. And I don't see the bench on.
Very.
I don't see the courtroom.
Can you hear her now?
Do what?
Just making sure you can still hear her.
I can hear you, but there's an echo. There's an extra machine turned on there. Somebody's got a computer on. It needs to turn off. It's echoing.
Both of those. Gotta have
I also don't see a photo. I don't see a picture up from the courtroom. So your computer at your desk needs to be turned off, and the one looking out toward the podium needs to be turned on, and the video hit on that. There you go. Now make sure it's pointed where that we can see the participants. That's pointed toward the ceiling or somewhere. Okay, turn it around toward the podium where the people are going to be speaking. That's the bench. Turn it around toward the podium.
Right.
On around the podium, right where they're going to come up and argue. Right there. Now we got it. Good deal. Okay, thank you. You got to turn yours off.
Which one is mine? This one?
I don't know. The one that's pointed out toward them stays on, and everybody else has to mute their video, their audio. Okay, let's try it now. Okay, that's got it. Okay, this is Haney versus Haney.
Yes, Your Honor. I'm gonna step up here. How's this?
No, it's not where you're standing. It's doing it. Somebody's got an extra computer on there somewhere. Melissa, do you have yours off?
Yeah. Let me check.
Does anybody else in the courtroom Anybody else in the courtroom hooked to Zoom? Okay, now try it, Mr. Cross.
Hello. Maybe, what about my outside?
It doesn't have anything to do with where you're standing.
Or my phone?
Hello? Hello? Can't hear anything now. That one there has to be turned on and the other ones have to be turned off. Get Megan on the phone and ask her. I can't call her because I'm using my iPhone. Turn the audio on the one that's looking out there on. The one that's looking out at Mr. Cross. Reach up there and turn the microphone on.
Then when I click approve without it.
Okay, now, Melissa, is your other one audio turned off on your other one?
Right. Gotcha. Next.
Okay.
There.
Okay,
Hello?
thank you.
We're good
Yes.
Well, I don't know. Good, we're audible. Okay.
Okay, Haney versus Haney.
Your Honor, what's happened in this case, you entered an order last motion day for Ms. Haney to appear and bring the children here. And unfortunately, we've never, even though my client's prepared to testify that she's aware of this hearing, we've never got her personally served with your order. I think that the address was incorrect. It may be my fault. But we're going to resend it to the sheriff in Indiana to try to get her reserved. If the court wants to operate under the same terms and get her here the next motion day, all I'll say is it's summer vacation. It'd be a good time for him to, when he gets them in June, to keep them for a while. Correct on?
I don't know whether I can compel her to come back or not, you know.
Well, she's submitted to the jurisdiction of this court. I mean,
Well, I understand that.
Yeah.
But that means that the sheriff or somebody's got to take her into custody or something, and I don't know whether they'll do that or not on civil orders, what I'm doing.
well, what we wanted to do is serve her and understand where she had to be here. And then the court can enter orders when she's here or if she's not here, as long as we give her proper notice. That was my.
I understand that, but what I'm telling you is the practicality of things, the way I've learned them, is that if we've got a civil enforcement order until she crosses over in this state, even if it's a contempt, that they're very likely to take her into custody or extradite her on a civil order. You agree with that?
I do, Your Honor. And
Okay, well, we'll just do the best we can. You notice her the next time.
I will read the next one.
Thank you very much.
Draft the order.
Okay, Carter versus Carter. Carter versus Carter. Somebody moved my computer. It's not looking at the podium any longer. Okay. Carter versus Carter. No one showed up.
Your Honor, there are two Carters on the docket. I would just like to clarify if you're calling.
Brandy Rochelle Carter versus Donald James Carter. 17 CI 00161. Miss Ridings was on it. Kelly Kirby Ridings. Okay, we'll pass over that case. Mid-South Capital Partners LP versus Spring Creek Liquidation.
Good afternoon, Judge.
I just saw it's a motion to disperse funds.
Yes, Your Honor.
What kind of sale was it? Was this a tax lien?
Yes, a series of tax liens over a period of years, and it was the airport subdivision, a lot of lots sold.
I didn't see any breakdown of legal fees or that sort of thing. It just had a check going to the plaintiff. I guess they're going to disperse the legal fees out of that. Is that right?
Yes, Judge, the county will include those fees, and the other parties had their fees calculated in their request. And what we did is we calculated them again to give it a pro rata share, because there wasn't enough funds for everybody. So we filed an amended motion. So it should take everything into account. And of course, Norwood's been paid and everything, all the costs have been paid. So they were just funds to distribute. I've received no objections to the motion.
Okay, just submit the order.
I will, thank you very much.
Jackson versus Gibson. Jackson versus Gibson.
Yeah, just call the case. My clients are there also.
Do what?
I was talking to the Bale judge.
Are your clients there?
Yes, they are here. They're coming in.
Okay. Do they have the child?
Do, Judge.
Yeah. Now, do y'all want to have a hearing on this today?
Yes, Your Honor.
Okay, well, we'll pass it to the end of the docket and get your people prepared for the hearing.
Thank you.
Your Honor, in regard to this case, I represent the father. He's not here. He works out of town, Mr. Gibson. And I think the battle is between Mr. Bertram and Mr. Garman. If I could just advise the court of what his position is, and we won't.
Well, you can advise us when we come back to it. Because
Thank
we're going to have a hearing on it. Okay, thank you. Mid-South Capital Partners LP versus Spring Creek Liquidation. We just had, is that a sister case to the other one we just had? Yeah, this is 20 CI 00120, and the other one was 19 CI 00180.
Gary Little League.
Yeah.
Mr. Little.
Judge, the order that he presented has both case numbers on it.
Okay, all right. That's good. Commonwealth Kentucky bound the Secretary of Finance versus somebody. I can't, it got cut off here.
Commonwealth of Kentucky versus Spring Creek Liquidation.
No, this is 20 CI 00129, Commonwealth Kentucky, Clinton County versus someone. It's cut off. Could you get the file and read the whole title there, Melissa? It is 20 CI 00129.
Okay, if I go by the first name for the committee parties, Commonwealth of Kentucky versus Spring Creek Liquidation LLC et al., JP Silverton, Mitchell K.
Okay,
SRE.
was that included in the other distribution order also?
Yes, sir.
Okay. 3 is off the docket on that one. Okay. People's Bank and Trust of Pickett County versus ESTA. Is anybody there on that case?
Nobody's here right now, Judge.
Okay, we'll pass over that case. Nation Star Mortgage, DBA Champion versus Melton.
Good afternoon, Your Honor. I hate to say that Your Honor is under the weather, sir. Your Honor, Maria Stewart today on behalf of the plaintiff. Your Honor, this is plaintiff's motion for summary judgment, default judgment, and order of sale, Your Honor. I am unaware of any objections, Your Honor.
Okay, was this a mobile home?
I believe there is a mobile home involved, Your Honor.
Okay. Okay, we got your $200 there.
That fee has already been paid to my knowledge, Your Honor.
Okay, we'll submit the order and I'll sign it. Okay, thank you very much.
Your Honor, did you say to submit the order or you have the
No,
order?
just submit it. I don't have it with me here. It's over there. I anticipated being there today. So they'll get the orders over here and I'll sign them just as soon as I can, okay?
Understood, Your Honor. Thank
Unless you want to come over here and bring the orders and visit someone who has COVID, then are you that desperate to get it or?
Well, Your Honor, that's funny. When I arrived in court and heard that you were in Cumberland County, I came from Cumberland County since my parents live in Cumberland County. So
Who are your parents? Who are your parents?
Larry and Kinzada Woods, Your Honor. They retired to Burkesville about 15, 20 years ago.
Yeah, well, that's the only reason people come here. They retire here or they're on a witness protection list or the other.
Well, my parents love to fish. And so that's one of many things that attracted them to Burkesville.
Okay, well, thank you.
Your Honor.
Yeah.
Your Honor, that concludes my business with the court. May I be excused?
Absolutely, absolutely.
Thank you, sir.
76 Falls Vista versus Freddie Robinson.
Hey, Judge, I have Mr. Connor on the speaker.
Okay, Mr. Connor, can you hear me?
Barely, Judge.
Okay, go ahead and make your case.
Summary judgment. We were before the court, and the defendant had filed his own response to the case.
Well, you previously tried to come in on it.
For the defendant, I've not been served. I've not received any notice that counsel has entered an appearance. Is anyone representing Mr. Robinson today?
Are you Mr. Robinson?
Yes, sir.
Okay. Mr. Robinson is in the courtroom. Now, is this the case you previously tried to get a default judgment and Mr. Robinson had filed an answer but hadn't served you?
Yes, that is correct, Your Honor.
Okay. Now, Mr. Robinson, have you obtained legal counsel yet?
No, sir.
Well, there's a problem here.
Okay.
I didn't do a default judgment against you, even though your answer was not properly filed, because I try to protect people. But now we've got a motion that was a default judgment because you hadn't filed an answer. And Mr. Connor filed a default motion because he didn't have a copy of the answer. It was in the file. So when I brought it to his attention, he's come back and now he's filing a motion for summary judgment. Now, there are certain things that you have to do to respond to a motion for summary judgment. A motion for summary judgment means that the other side cannot prevail. Now, I've read the affidavit from the people that conducted the sale, and I've read Mr. Connor's motion. Now, why don't you have an attorney in this?
I represent myself.
Well, you're not doing a very good job at it, is what I'm telling you. And no one else would either. It's no reflection on you. There are civil rules that we have to follow, and they require, this is not small claims court.
This is my first time even doing something like this.
Well, I know that's the reason that I'm explaining it to you. I'm not getting on you about it.
Sir.
If it's in small claims court, you can go in and the judge goes back and forth. So I read the affidavit, and the evidence is pretty strong that there is buyer's remorse in this thing. So I'm going to give you to the next rule day. You need to get an attorney if you want one.
Okay.
And you need to file a response to this within 15 days. And I'm going to redocket this motion on June the 9th. So you need to get a copy of the file there, the complaint, the answer that you filed, and take it to an attorney. Okay, as soon as you can.
Sir.
Okay. Okay. Thank you, Mr. Connor.
Thank you, Judge.
Yeah. Letitia Janelle Carter versus Clifton Ray Carter.
Good afternoon, Your Honor. Michelle Fisher from Apple Red Legal Aid representing Letitia Janelle Carter. We're here on my motion for relief from the order you had issued denying my client's motion to proceed in formal papyrus. My client's not able to be present this afternoon, Your Honor, because she herself had a medical emergency while in form of her child. So she has to be at the doctor with him. However, there is an affidavit in this case, which I believe the court could consider and sufficiently make a ruling on today, if the court would do so. The basis for my motion is regarding the federal poverty guidelines, which were updated. For those guidelines, the income for a family of four is $27,750. My client's income, counting the SNAP benefits, falls at $27,384. So it's below.
I can't understand what you're saying. You need to drop, everybody stand away from you, drop your mask if you don't mind.
Yes.
Okay, everybody step away from her, okay? Now, I can't understand what you're saying about the poverty. When did they change?
They're updated annually, Your Honor. I've got it referenced in my motion for consideration referencing the new amount. It was updated January 21st of 2022. It looks like pulled from the annual update of the HHS poverty guidelines.
Now, are you counting the SNAP benefits?
Yes, Your Honor. Counting the SNAP benefits, which Apple Red would argue we do not have to. However, in this case, even counting those, her income would only be $27,384, which is beneath $27,750, which would put her under 100% of the federal.
By how much? $150 or so?
It is by approximately $400, just
$400.
math, Your Honor.
Mm-hmm.
And that is counting the SNAP benefits. Now, the Census Bureau itself does not count non-cash benefits when it is configuring those guidelines. Non-cash benefits would include arguably SNAP benefits, but even so, counting
Does your client work?
No, Your Honor, she's disabled. She's disabled. She has 3 children.
What kind of disability does she have?
I'm not entirely.
No, I'm not asking the physical question. Is it Social Security?
Yes.
Workers' comp?
It is SSI. She receives
SSI.
41 a month.
Okay. Well, if that's the level that people get to do, inform, with nobody in Clinton County will have to ever pay any filing fees. So Burchett, that would be pretty much inclusive. Is that, what about a household? That's a household of how many?
That's a household of 4, Your Honor, which is the size.
Yeah, okay. Well, submit your order.
Thank you, Your Honor.
Yeah,
That concludes my business with the court. May I be excused?
absolutely. Thank you.
Thank you.
Lower versus lower. Okay,
Your Honor, this was the respondent's motion, and we came to a temporary agreement on a few of the items. My client would remain in the marital home. She would have temporary sole custody of the children. The county attorney would calculate child support, and they would need to produce their income out there tomorrow to the office. He will continue paying the boat payment at the amount of $278 in lieu of maintenance. If the boat sells, he would pay directly to her $278.
for how long?
Sorry,
For how long?
until,
Further orders.
yes, until we have a hearing. The time sharing right now would be supervised by her mother from 1 to 2 p.m. on Saturday. This is also temporary to let the children get readjusted to him. There's a pending DVO between the parties, so her mother would be willing to supervise that, either at the park or he could contact her mom if he'd rather meet at her house or wherever.
Okay, well, if both you parties agree to this?
Yes.
John, you agree to that?
There was one other provision that we did agree to do, I should mention, is they have a boat and she would market that for $18,000. And we've come up with a price that they would probably agree upon, Mr. Cross and I. And he's gonna furnish her a key where she can show the boat. And we'll put.
Well, we're on, since we're live on, don't tell them what the lowest dollar that they'll take.
I did not.
Kind of ruin the market.
But we know what the price is.
Well, that's good. That's good. Everybody out there in YouTube land doesn't need to know what. Yeah. Okay. Okay. Well, thank you all very much.
Pre-order, Your Honor. Thank you.
Okay, thank you very much. Okay, now let's go back on the docket. Was it Caitlin versus Gibson's the one we were supposed to go back to?
Yes, sir.
Okay. Okay. Now, was Lee Wittenberg originally in this case and I let him out?
He was, Your Honor, but he's no longer involved.
Yeah. Mr. Bertram's in it. Okay, Mr. Bertram, you want to?
Procedural matter we probably need to address before we begin the hearing, the scope of the hearing.
Your Honor, what I'd like to do before you get into anything, as I say, Mr. Gibson is the father. Would the court like to hear from me now?
It seems appropriate.
Thank you, Your Honor. Mr. Gibson works out of town. Some weeks back, Mr. Wittenberg agreed to order that basically transferred custody over to the mother. Mr. Wittenberg has since been replaced. That order had not been entered because we had to consult with Mr. Gibson on that and get him to sign it. Mr. Gibson's position in this case is that continues to be his position. He believes custody and possession ought to continue to be vested in the mother, and he's not here to testify, so I don't know if we as his counsel.
Is he in this lawsuit?
He's a party.
Yes.
Is he a party? I'm asking you if he's a party.
Yes, he's a party. He is.
Yeah. Well, we'll go ahead. If you're here to represent him, we'll go ahead and have testimony given.
Yes, we're not asking that it be held up, and in fact, we will waive our presence to a certain degree. I don't think we're going to be an active participation in the.
Well, so you're wanting the mother to get the child, is that right?
Yeah.
Well, that's kind of a change. That's a kind of change in position from earlier, I think, but maybe not. Okay. Okay. Who wants to call? Mr. Bertram, you want to call the first witness?
first on the scope of the hearing, I think we need to have that clarified first.
Okay, I can't tell who's talking here.
It's me, Your Honor, George Bertram.
Okay, you move towards the center of the microphone. Let me have it.
Okay, can you hear me now?
Yes.
Okay. On the scope of the hearing, Your Honor, the court entered an order on April 18th, directed that all pending motions be scheduled for hearing by this court. And I filed a motion to reschedule my motion for immediate return of child custody to the mother. And no other motions were filed until yesterday. Mr. Garvin filed a motion requesting a de facto custody hearing, a temporary custody hearing, and a permanent custody hearing. A rather lengthy motion, and I don't think that we need to get into all that today because my motion is just for temporary relief only and on return of the child to the mother, and nobody else has standing at this point to challenge their claim.
Hey, what do you have to say, Mr. Garvin?
Judge, in response to that, if you'll recall, we had a conference call. Well, Your Honor knows what the order said. It said that there would be the motions would be heard on a day certain. We were supposed to schedule those. That never got scheduled. I take fault in that in the sense that I was off a couple of weeks with the birth of my child. And I had explained that by email to everybody. Now, we had a conference call Tuesday, at which point Your Honor said that he requested my people to be here in Kentucky for this hearing on this court date to hear motions. I got the motion filed yesterday, but it was filed less than 24 hours after the conference call, and that's really all I could do to get
well,
this.
I really didn't anticipate that your clients would make it today, and I was prepared to give them an extension. I was going to hold them in contempt and fine them a certain amount of money and let them purge themselves by being here next rule day. But you know, the communication that I got was outside of the line of communication. I think we got an email. I hope you copied it to Mr. Bertram. Mr.
Yes,
Bertram.
Your Honor, my understanding was that they would not be.
Would you copy that email to Mr. Bertram?
I believe so, Judge. Yes, I think I sent it to you, Megan, and Mr. Bertram.
Did you get that email, Mr. Bertram?
I got an email along those lines, Your Honor, I think.
That was my understanding, and then my clients.
Yeah, well, I'll just tell you, I don't like to be critical of anybody, but this has been a poorly practiced case. Poorly practiced, and I understand that you've had a baby, and it's a joyous occasion. Everybody over here that's related to you is happy about it. But whether you have a baby or whether you have COVID or whatever, you're responsible for getting somebody to cover for you if you can't do it yourself. Now, your clients have come all the way, I guess, from Arizona or wherever they're from. And I cannot allow you to hear the motion that you filed here today, but I will hear the other motion. And then y'all can schedule another situation, but I will want to talk to them. And are you planning, Mr. Bertram, are you planning on calling them?
Calling the other party? No, Your Honor. I just plan on calling the mother as a witness.
Well, I'm sure that Mr. Garvin will call them as a witness in the case. Is that correct, Mr. Garvin?
Well, Judge, if we're not able to put on their motion, I don't think we will have standing as de facto to be considered for custody today.
I'm not going to consider that, but they might have information of worth concerning whether or not there ought to be an emergency relief to tell me how the child's doing, where the child is, that sort of thing. But sure, if you don't want to call them, I can understand that.
I'd be happy.
Okay, Mr. Bertram, you call your first witness.
Thank you. Your Honor, I would call Caitlin Jackson at this time.
Okay, she can stand there next to you. Will you raise your right hand, ma'am? You swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay.
Would you state your name for the record, please, ma'am?
Caitlin Hughes.
And Ms. Hughes, do you have any children?
Yes, I have my daughter Lila and my son Brandon.
Okay. And is Lila the child that is the subject of this litigation?
Yes.
And is that is that a father of the child, Jordan Gibson?
Yes,
Okay. Shortly after the birth, Lila's birth, were you subjected to a period of confinement?
yes,
And in preparation for that period of confinement, did you have to consider temporary caretakers for your child, Lila?
yes.
Okay, did you have a number of options there, or did you just have one?
I had multiple.
Okay. And could you tell the court why you chose your mother as an option and why?
I just felt like it was the best option, and we had an agreement that that as soon as I was able to have my daughter back, that my mother would bring her home.
And did your mother live in Arizona at that time?
Yes,
Was that a concern of yours that agreement be enforced due to that distance involved?
yes,
Okay. And were you in fact released from confinement in February of this year?
yes,
And at the time that you were released from confinement, did you ask your mother to return the child?
yes,
And did she return the child or tell you that she was going to?
no,
Did she in fact institute custody proceedings in Arizona
yes,
and emergency custody proceedings?
yes,
Okay. Did you have to retain an attorney in Arizona to defend those proceedings?
yes,
Did your mother tell you prior to that time that she would not institute any type of legal custody proceedings against you?
Objection to leading.
Just ask a question.
Okay. Were you surprised by your mother filing these legal proceedings in Arizona?
yes,
Had you all had any discussions about the filing of legal custody proceedings regarding the child?
no,
Okay. So your mother did not, what was the result of proceedings in Arizona?
they were all dismissed.
Okay. Did you,
Well, that's not exactly true, because the judge out there contacted me, with the interstate thing, and he relinquished. So there weren't any factual findings, and I have information about that you might not have. Okay. You agree with that, Mr. Bertram, that they were transferred back here?
I would agree they were transferred, but she had made several efforts to get an emergency.
Okay, that's fine. Okay.
That's what I was talking about. But in any event, you hired an attorney here in Kentucky and to seek custody of this litigation, did you not?
Yes,
Okay. Did you at that time voluntarily go to secure drug testing and drug monitoring?
yes,
Okay. And were there allegations being made that you had a drug usage problem?
yes.
Okay. Where did you go and what type of monitoring devices did you secure?
I went to David Bookout through D-Trex to get the sweat patch.
Okay. Was that applied in February of this year?
Yes,
Have you worn those patches consistently since February up until today's date?
yes,
Do you have one of the patches on you here today?
yes,
Have any of the results of those tests been positive for any illicit drugs?
no,
Okay. In addition to that, are you familiar with a Shelby Delk at Community Interventions?
yes.
Okay, can you tell the court who Shelby Delk is and what you consulted her about?
She is my therapist, and I consulted with her about reunification therapy to have some type of therapy to rebuild the bond between my daughter and I.
Is she recommended 6 or more sessions of reunification counseling?
Yes,
Okay, when is the first reunification counseling session scheduled for you and your daughter?
May 19th.
That's a week from today.
Yes,
Okay. Now, I think you recently had another child. How old was that child?
he's 10 months old.
Are there any type of investigations regarding abuse, neglect, or anything like that going on that you're aware of pertaining to you?
No,
Okay, so is anybody else a caretaker of the child other than you?
my husband.
Okay. But Who is the primary caretaker for your child?
I am. He works. I'm a stay-at-home mom.
Okay. And while you were separated physically from your daughter, were you allowed to have contact, electronic contact with her?
Yes.
Did your mother arrange that? Did you and your mother arrange that?
Yeah.
By agreement?
Yeah.
And tell the court what type of contact that was and how frequently it occurred.
It is through Facebook Messenger video, at least 3 to 4 times a day, if not longer, or if not more, I'm sorry.
Okay, and that went on for how
long? That's gone on the entire time she's been gone.
Okay. Up until the present time?
Yes.
Okay, thank you. Do you, and have you reached an agreement with the father of your child, Jordan Gibson, in regard to custody?
Yes.
And that you execute an agreed order with Mr. Gibson about custody of the child?
Yes.
And is this actually your signature?
Yes.
On there? And was Lee Whitmer representing you at the time?
Yes, he was.
Is that his signature on there as well?
Yes.
And has Jordan also signed the document?
Yes.
And Daly processes?
Yes.
Okay, without going into detail about the order, just the order.
What's the date of that agreed order?
It indicates it was notarized on February 16th of 2022. And does this order grant you solid custody and control?
Well, actually, it's not an order, it's an agreement, right?
Yeah, well, it's an agreed order, is the title of it. Just had.
Did I sign it?
No, you did not sign it. It's a proposed agreed order.
Okay.
So that reflects Mr. Gibson's agreement that you should have some custody.
Correct.
Okay, is he familiar with Lila and her needs?
Yes.
Okay, is there any concerns that he have, or they expressed to you by him?
Yes.
Okay. Does he have any concerns about you having custody of Lila?
Objection calls for yourself.
That have been expressed to you?
No.
Objection calls for yourself.
Do you receive any type of assistance in regard to having custody of your newborn child?
No.
No. Are you currently employed outside the home or doing anything else of that nature that will take your attention away from taking care of that child?
No.
You have adequate resources to take care of both of these children. Lila.
You don't receive K-CHIP insurance for the child?
K-CHIP insurance.
What is that?
What kind of insurance do you have on the child when you go to the doctor?
Oh, he has passport.
Well, that's through K-CHIP. That's a Medicaid program, a K-CHIP program. You don't pay for the passport, do you?
No, sir.
Okay, so you do get benefits there. You get free insurance.
I didn't understand.
Do you get EBT? You get food stamps?
Yes.
Okay. What else do you
I
get?
also get WIC.
Well, I mean, okay. I don't have any problem with anybody getting it, but I just don't like people to say they don't get anything when they're getting considerable benefit from the taxpayers. Go ahead.
I didn't understand the
I understand. It's to the point where it doesn't seem to be a benefit anymore. It's just something that people are entitled to. So go ahead.
Okay. Does Jordan Gibson pay child support for Lila?
Yes.
Okay. What's the amount of child support that he pays?
180 a month.
Okay. And how long has he been paying that?
Since February of 20, I believe.
Did you receive that amount directly, or does the state take that in?
I receive it.
You receive it. Okay. So you receive $180 a month from Mr. Gibson.
Are you talking like to the child support office?
Do you receive $180 a month pay budget with
Yes.
child support? Okay. Do you have any debts or obligations of any kind that interfere with you taking care of Lila financially and other needs?
No.
Do you have any objection to your mother continuing to have contact or visitation with this child as a grandparent?
No.
Are you willing to allow your mother to have contact similar to what electronic contact with Lila at the same time that she allowed you to have?
Yes.
That's all.
Is her mother in the penitentiary?
Mine?
Yeah, if she's there,
Oh.
that's the reason she allowed you to have electronic contact with her, because you were in the penitentiary, right?
No, that's how it's been the entire time over my phone.
Yeah, but were you in the penitentiary?
Not the entire time. I was also in rehab.
Yeah, how long were you in the penitentiary?
I'm not 100% sure. A total of 6 months.
Okay, and then you were in rehab for how long after that?
For 3 months.
Okay. Okay, I don't have anything else. Mr. Gartman, would you like to inquire?
Your Honor, if I could clarify just one thing on the electronic contact, them being in Arizona, since she's been out since February, they've allowed her to have frequent contact with the child by video. And we're just merely saying we have no objection to allowing her to do that as well.
Okay, well, I thought would be in a little different position. I mean, during 10 months or so of that, they allowed her to have that because she was incarcerated or somewhere. But go ahead, Mr. Garman, you want to ask anything?
Mr. Cross is going to step in and say, I have no further questions of Ms. Jackson, that I'm going to waive further presence on her behalf or on Jordan Gibson's behalf, since we don't have anything else to be involved in.
Okay, Mr. Garman, do you have anything?
I do, Your Honor. Can you hear me, Judge?
Yes, I can.
Okay.
You need to get on screen, though. Mr. Bertram, you need to back away to your left, to your right, excuse me, your right. Okay. Go ahead.
Ma'am, you said you relinquished custody to your mother in May of 2020. Is that right?
Correct.
And you did not proceed to file anything to get custody back until February of 2022?
Correct, on the grounds that we had an agreement that she would bring her back and not file.
That wasn't my question. You never filed anything during that time, did you?
No.
Now, you and Jordan signed that agreement on February 16th of 2022, I believe you said?
Yes.
And that was only 4 days after you got out of jail.
Correct.
You got out on February 12th.
I got out on February 9th.
Got out on February 9th, so that was 1 week after you got out of jail. What were the circumstances of that agreement getting signed? Who drafted the agreement?
Mr. Wittenberg.
Okay. And was that at your request?
Yes.
Why was it your request to get a custody agreement with him immediately, knowing that my clients were involved in the case or getting involved in the case?
Objection calls for a legal conclusion.
I think that's correct. I think that does call for a conclusion. The way it's asked, it may be asked a different way.
I do want to ask you, you said you got $180 of child support per month from February of 2020 until now?
Mm-hmm.
Was that yes? And you didn't see the child until today for the last 18 months, is that correct?
Incorrect.
In person?
I saw her on Thanksgiving of 20.
And that would have been 18 months ago, correct? November to May.
I'm sure.
Okay. So that's 18 months worth of child support that you collected, at which time you never saw the child. Did you forward that money to the Hodges?
I told them that I would, and they denied it and told me to keep it.
So that's a no. You never forwarded. Is that correct?
Correct.
In fact, you never provided anything for your child's outside of Christmas presents for her during the 2 years she was gone from you, correct?
Incorrect.
What did you provide for
We have bought her clothes. We have sent her toys.
For Christmas and birthday?
No, at random.
Okay. Do you know when?
I don't know exact dates.
Okay. Do you know how many times you did that?
No, sir.
Now, you also testified that the Hodges wouldn't let you or wouldn't bring the child to you when you asked, correct?
Correct.
Why would it be their responsibility to bring the child to you?
My mother took her from Kentucky.
Okay, but again, why would it be their responsibility to bring her to you? I mean, you asked them for help, correct?
Correct.
Okay. Would it not have been your responsibility to go to Arizona and get the child?
I was told that I'd be arrested upon my arrival if I tried to get her.
Told by whom?
My mother.
Arrested for what?
Breaking parole conditions.
And did you ever check with your parole officer on that?
Yes.
What did he say?
He said yes, and he gave me permission to be out there for 3 weeks.
So you were allowed to go get the child?
Yes.
And you did?
My mother continued to file things, and I was advised by my lawyer to wait until court.
But the answer is nothing was stopping you from getting the child. You never went, correct?
I mean, I was being told by 2 different states on 2 different laws on what I could and couldn't do.
Okay. And the answer is you never went and get the child?
No.
Okay. And you would agree with me that the Hodges have been solely providing for your child for the last 2 years, correct?
Yeah.
That's all the questions I have.
Okay, do you have any redirect?
I have only one. After the Arizona proceeding was dismissed, did you purchase airline tickets to go out to Arizona and pick up your child?
Yes, I purchased tickets twice.
Did you make copies of the last tickets that you purchased and provide them to me so that I can file them with the court?
Yes.
You understand that those tickets were filed with the court?
Yes.
Okay, and were those tickets for you to, how much did they cost?
I think right at $1,200.
Okay, and you bought those tickets and they were to allow you to fly out to Albany tomorrow? Correct?
Fly out of Nashville tomorrow.
Fly out of Nashville tomorrow, and you would come back with your child, when for the tickets?
Saturday.
Saturday. Okay. And that's all.
Okay. Now, I do not expect, I'm going to take this under advisement. I do not expect these individuals, the mother and father, to have to go through the expense of coming back here again for a hearing. So I'm going to allow you to go ahead and take their testimony here today, and you may cross-examine them on anything that would impact the de facto status. So Mr. Garman, you can call them in the case in chief. You can, Mr. Bertram, you can cross-examine them, and then I'm going to give Mr. Bertram 20 days to take a look at this motion, file a response to it, that sort of thing. It's not fair to spring it on him the day before. So, and then he can decide if he wants to take additional testimony. It will not stand submitted until he feels that he has secured all the testimony he's comfortable that he needs. Okay.
Is a possible alternative. We've discussed this. We would have no objection to taking their testimony in Arizona via Zoom with Norm Sullivan. That would help.
Well, that'd be fine.
Judge, I would prefer also to get, if my motion's not going to be taken up to, I would prefer to get all the testimony on one day regarding the de facto, if possible.
I think it makes sense to do that.
Okay, subject to my right to cross-examine at a later time. Yeah. Okay.
You can cross-examine them today, and I'll let you cross-examine on Zoom at a later time.
No, I'm sorry. I misspoke, Judge. I meant that I would prefer to do all the testimony on a day certain. So we're not.
But you don't want to do it today?
I'm sorry?
No, you're not clear to me. You want to do it today, or you want to do it all on Zoom?
I'd rather do it all on Zoom. I'd rather do it all on one day where we get everything together at the same time.
Well, this was the day that you were given. So if y'all want to agree to do one, but now I don't want it to linger on any. As a matter of fact, I probably won't decide this first motion until we hear the second motion, because I'm not getting to hear everything I need to know. I mean, hearing one side of it, what they agree to, what she said, that sort of thing. And there are certain findings I'm going to have to make at some juncture, but I'll take it under advisement. So y'all schedule a day real soon now that you're going to take care of this. Now, before the parents go back, the grandparents go back to Arizona, is there going to be arrangement for this mother to visit with a child physically here today somewhere?
Yes, Your Honor, we can certainly do that.
Well, Your Honor, if the child's gonna be allowed to go back to Arizona with the grandparents, we would certainly want to hear the testimony today. Anything that would help expedite the child staying here with the mother is what we would want.
Well, the child is not going to stay here with the mother today. You know, I have reservations about the thing. I'm not going to say that she won't ultimately get the child here, but I just don't have enough information to determine this thing yet. I mean, I haven't heard anything really. So I will tell you, can you set this Zoom up within 10 days, Mr. Garman?
Yes, Your Honor. For Marion, we can for sure.
Well, for who?
I can make myself available.
Judge, we can do it the later part of next week. I'd be happy to.
Well, let's get it. Let's make sure it happened, because this mother has in my opinion, has a right to have some resolution to this thing, you know, one way or the other.
I agree.
So do the grandparents. So you want to do it by deposition form, or you want to have a hearing by hearing form? Which way you want to do it?
I would probably say it'd be easier to do hearing, Judge, then we won't have to deal with transcripts and further delay from that.
Okay, well, you can connect with Commissioner Soam, and he'll take the testimony and submit it directly to me. Okay?
Thank you, Your Honor.
Thank you, Judge.
Thank you all very much. Does that conclude the docket?
I think that's all of it, Judge.
Okay, thank you all. Sorry I wasn't able to be with you today.
You get to doing better.
Okay, see you later. Bye.
You want to talk, right?